on 4th August. But on 4th, I had some personal difficulty. Mr. Mahapatra is there. Can the matter taken up on the 5th August instead of 4th August? Just order passed by your lordship.
My lord, may I be permitted to mention, my lord, I am for the appellant.
Let his matter get over. Theater.
May I be permitted to mention? My lord, application for stay. I am for that.
Okay.
My lord, one application for section 5, my lord. Condonation of delay application for inclusion.
This is my lord, appearing, my lord, it will appear on 9th July, as per your lordship, sir. But matter did not appear. Just fixed on 9th July. I have already given a thorough copy of the order.
Okay.
Appeal inclusion.
My lord, may I, my lord, may I crave your lordship's kind leave? My lord, I am virtually mentioning item number 196, my lord. This is fixed for today at 2 p.m., my lord. My lord, I'll be praying for accommodation on my personal grounds, but I'll be leaving Calcutta today, my lord. I have a, my lord, if your lordship kindly grants me accommodation for today, my lord, my junior will be there. I had a talk with the other side, my lord. If your lordship, my lord,
Which matter?
196, that matter, my lord, where the, my lord, I am praying that the inquiry may be closed.
But
SN
today it
votes.
was fixed for orders.
Yes, my lord. I'll be praying for accommodation for on my personal ground. If your lordship kindly keeps it on Monday,
You
my lord.
ask your junior to
Yes,
be
yes.
present.
I will. Deeply obliged.
Item number 3. I am for the matter appeared. I filed this under the paper book. My lord, I submitted that Mr. Pari appears for the insurance company. My lord, let the hearing be fixed in the monthly list of November. It will take time, my lord.
On the prayer of learned advocate representing the appellant claimants, let the matter be fixed on 14th of November. The learned advocate representing the respondent insurance company is present. Next.
I for the appellant, Lord.
My lord, I am for the stay.
This is your lordship, Lord, was hearing the matter. Your lordship fixed the matter for filing of written notes, but I could not do it. Your lordship would kindly fix the matter in the next week. I'll take 10 minutes of your lordship's time and I'll conclude my hearing. Conviction of 490 to 306.
On the prayer of learned advocate representing the appellant, let the matter be fixed on 11th of August. Learned advocate representing the state is present.
11th, Lord, I have some personal difficulty. I'll be going out of Calcutta for my daughter's admission. So, Lord, 12th or 13th, any day, Lord, dear lordship.
13th of August. And you should be there positively.
I'll come. I'll not take much of your lordship's time. 10 minutes will do.
Next.
Item 5, my lord. Small correction, page 5, my lord. Regarding, my lord, kindly see. Regarding, my lord, date of filing only.
Date of filing.
My lord, corrected copy. Page 5.
তো সময় নিলে মুশকিল ওনার থেকে দিন ওটা
Only, my lord, paragraph,
page
page 5, paragraph 9.
page 5
Paragraph
Paragraph
9, my
nine.
lord, date of filing have been written, that is, my lord, 23rd February 2017. It will be, my lord, 18 September 2013, my lord.
Okay. এটা নিয়ে করে দেবেন ওটা। Next.
My lord, this is my appeal. My lord, it is a case of a minor. My lord,
Who is your other side?
my lord, there are two insurance company. For one insurance company, Mr. Rajesh Singh appears, and for another insurance company, Mr. Sucharita Pal appears. Your Lordship, kindly see the order dated 16 October 2023. 16 October, where His Lordship, the Honorable
Now-
Vivas Patnaik, I am filing the my lord, an application under Order 41, Rule 27, taking additional evidence of disability certificate. Because the minor lost my lord, both my lord, hearing and my lord, speaking power. It amounts to my lord, my grounds are taken for my lord, 100% disability. Now, my lord, on that day, my lord, his lordship desired asking the my lord, opposite party to file affidavit in opposition and reply immediately. Till date, my lord, there is no reply, no opposition have been filed. Let it be fixed in the month of November because it will take time. In the meantime, my lord, if they well, desire to file the
For the submission of learned advocates representing the appellant claimants, none appear to represent the respondent insurance company. On the prayer of the learned advocate representing the appellant claimant, let the matter be fixed on 17th of November. Next.
Seven, my lord, there'll be some correction. My just my may I tell you, Lordship, what happened? A bachelor died.
No, tell me the
No,
correction to be made, which
well,
portion?
Page
Page
4.
four.
Page 4.
দিয়ে দাও, ওটা দিয়ে দাও, ওটা বলো।
একটু
ওটা দিয়ে দাও।
Which paragraph?
page 4, paragraph B.
Paragraph?
Small
11B,
11B. 11B.
last line.
The sister, brother, and
Brother, sister of the victim has been substituted and his mother was already on record. Subsequently, during pendency of claim case, mother was also died.
Mother also died.
In fact, in my memo of appeal, mother is not appearing, my lord.
did you file any copy?
No, my lord, in the code below, it has been recorded.
Recorded.
Acha.
Page 48, my lord.
So this is your submission.
And thereafter, my lord, page 19. Page paragraph 19.
Did you file any substitution application?
My lord,
That
kindly
part
see
of
here, my lord, the code below, in the code below, here, in the code below, my lord, paragraph kindly see. In the code below, substituted.
This you come at 2. Next.
My lord, I am for the insurance company appellant, my lord. Paper book has been filed, my lord. Your lordship can fix this matter for hearing, my lord. Only a short point is involved in this matter, my lord.
Who has filed the paper book?
well, I am
Paper book filed by the learned advocate representing the respondent claimant. Be kept on record. heard the submission of learned advocate representing the appellant insurance company. Let the matter be fixed on 19th of September.
My lord, grateful, my lord.
My lord,
Final one indulgence, my lord. There's an analogous matter, my lord. 272, my lord,
272 of?
2023, my lord.
FMA
FMA
272 of 2023. This is FMA 273, the previous matter. FMA 272 of 2023. This is arising out of the same accident, my
But
lord.
may I inform your lordship, my lord, paper book has not been filed in that matter, but that matter can also be heard without the paper book based on this matter, my lord.
I will file a paper book in that matter as well, if it is listed, my
If
lord.
it is out of the same accident,
Yes.
Same accident,
Same
my lord.
accident.
witnesses are same.
Same.
Everything is same, my
It is same.
Yes. Only the
judgments are different,
claimants
my
are
lord.
different.
Right.
Matlab-
Passed by different courts.
No, same court, same accident, claimants are different. But the accident, FIR, charge sheet, everything is same.
এই লাস্ট লাইনটার আগে লিখে দেবেন, the learned advocate representing the appellant insurance company submitted that a separate appeal being FMA
272, my lord.
of
2023.
2023 had been filed by a different set of claimants
My lord.
Yes.
arising out of the same impugned judgment and order as that of the instant appeal. The department is directed to place the case records of FMA 272 of 2023 along with that of the instant appeal on the next date of hearing.
Grateful.
My lord, this will appear for orders. Or
I have heard him, you did not say anything.
My lord, this can be this only.
My lord.
So on the prayer of learned advocate representing both the parties, let the matter be fixed under the heading for orders.
Deeply.
Nine, my lord, correction, my lord.
Page 20.
Page, my lord, first, kindly come to page 2. Page 2, my lord, paragraph 7. Page 2, paragraph 7, learned tribunal granted at sum of 10,86,509 together with interest that amount already they have received. Now, your lordship has already my lord, modified that amount. Kindly come to page 20. Page 20, your lordship has modified that amount and reassessed at rupees, my lord, 18 lakhs 30. দাঁড়াও না। My lord, reassessed that amount rupees 18 lakhs 31,509. Thereafter, your lordship directed my client to deposit that amount. That's
To deposit the balance sum. of-
Balance.
my lord, kindly mention. That's
Sir, you please don't, every day in the morning you people do this. Next,
my lord, then one pair. My lord, kindly extend that time, my lord. Only that pair. Extend that time.
these things you come early in the morning.
My lord. Only extend that time, my lord.
The learned advocate representing the respondent insurance company. How many weeks were it was given?
My lord, your lordship granted, my lord, 6 months from date of award. That is award passed on, my lord, 5th December
A
2024.
further period of 1 month to
Grateful.
comply with the order dated or date and number to be given. Next, 505 he says that the listing department has wrongly listed this matter. It has already been disclosed. No, not any
Money has
to
to
be
do.
passed. Okay. Mhm. Right. Judgment and order dated. Just date টা বসে দেবেন, হ্যাঁ? Passed by this court. Yes.
Under this appeal is filed by the claimant in the death case, my lord, where the tribunal dismissed the death case, disbelieving, my lord, the evidence of the, my lord, the eyewitnesses. Even if charge sheet was filed against the offending victim. My lord, doubting the case.
Now, what is the status
My lord,
now?
today I am filing, my lord, the paper book, let it be fixed, my lord, as for honors.
Can it be
Well-
fixed for others?
Well, a time taking matter.
Paper book filed by the learned advocate representing the appellant
Paper book
claimants
has
be
been filed.
kept on record.
Colony.
The learned advocate representing the respondent
Well,
insurance
paper-
company is
Paper will not charge to me.
Yes, paper book has been served.
serve it again if you have a copy. uh, is present. Has he given you?
No.
Next state,
My lord, kindly see, my lord, copy of information.
Mr. Monique.
That's all.
Next date be fixed on 12th of November for further hearing. In the meantime, paper book is to be served upon the.
He
I
If you-
in jurisprudence.
If he has not received it, give him a copy.
that is
I mean, you are
all right.
next.
Kindly see, my lord,
Our correction. What is it?
my lord, calculation part will be this, my lord.
Mr. Mondal, all these calculations part, whatever figures, whatever it is, write in a slip and give it to them. We are just wasting time in all these things.
Mrs. Paul was there, my lord. Your lordship will kindly, my lord, make it
Uh,
today, my lord. Perhaps on Monday she would come.
The learned advocate representing the respondent claimant is present. None appear to represent the
My lord, I am appearing on behalf of the respondent claimant. My lord, I am.
appellant insurance company. Let the matter be fixed on 5th of August. Next.
This matter, my lord, I filed the appeal, but subsequently, my lord, it was compromised between the time.
Then why did you mention?
I haven't mentioned, but probably not mentioned.
If you had not mentioned,
So
then
just
why-
yesterday night, I have informed that it compromised and they have received the money.
so you were informed yesterday night.
Yesterday night, but I
And
just
prior to that, you must have mentioned. Now, what are you intending to do?
I don't proceed to want to
You
proceed.
file a written
But I have to
instruction
written letter is required.
on the prayer of learned advocate representing the appellant claimant. Let the matter be fixed on 21st of August. In the meantime, you get a written instruction.
My lord.
Next.
My lord, I beg to appear for the respondent.
But I'm for the appellant. I'm praying for not today, as the matter has come suddenly, and I am not being briefed today. So kindly make it not today, my lord.
Yesterday also you had appeared in one matter.
No,
Yesterday or day before?
day before I have appeared.
Then in the same matter.
Not in this matter. This matter I appeared after a long time.
My lord, why this letter we had communicated to the other side for compliance of the last order, my lord, still hasn't been complied. We haven't been served.
Who has mentioned this matter?
Long
Either of you must have mentioned this matter.
my senior has mentioned this matter.
You people will mention, and thereafter it will be listed.
Lord, I'm apologize. I'll make it not today, Lord. On the next day, I will.
On the prayer of learned advocate representing the appellant Union of India, let the matter be adjourned for the day. Next.
The 16 is the insurer's appeal. The stay has been made absolute.
Lord, Mr. Roy, Amit Ranjan Roy is appearing for the respondent. Appeal was on the point of Lord involvement as well as quantum. Lord, I have not mentioned this, Lord. Your Lordship will kindly fix it up any day, Lord, for hearing. Whenever
Paper
my
book
Lord.
is there on
Paper
record?
book, Lord, I have received, Lord. I believe it
If
was.
you had
was-
not mentioned, then Mr. Roy must have
Lord,
mentioned.
must have been, Lord. I do not.
The learned advocate, the learned advocate representing the appellant insurance company is present. None appeared to represent the respondent claimants. Let the matter be fixed on 4th of November.
4th of November.
Next.
मतलब these activities, मतलब appeal involves claimants appeal involves hot points. One is denial.
Have you filed the paper book? Who is your other side?
I have
Hold on, I have nobody appears.
Nobody appears till now.
National Insurance
Lord, I'll
Company.
check it up. Lord, Lord, take it up on Monday or Tuesday whenever my Lord pleases me.
The learned advocate representing the appellant
Okay, I'll
claimant
call it.
is present. Next date be fixed on 6th of August.
6th of August.
I'm filing
You file it on 6th. Take it back. ওটা লিখে দিন ওটাতেই লিখো
পরেরটাও সেই
next
Same order.
same
Same.
Lord, on
Same
6th of
order.
your Lord will kindly get
Yes.
up, Lord, take it up.
same order 6th.
Lord, my appeal.
This appeal is already disposed of, my lord.
Your Lordship, we have filed a petition for changing the name of the insurance company. It has been amended Canta Devenectu. Can 3 of 25. Your Lordship will find that previously the name of the company was Liberty Videocon General Insurance, which has now been changed to Liberty Liberty
Insurance company insurance limited.
Insurance Company Limited. The General
Earlier
Insurance
it
Limited.
was Liberty Videocon General Insurance Company Limited.
Yeah, now it has Liberty General Insurance Limited.
Hmm.
Your Lordship, the problem is we cannot withdraw the money. That's why the amendment is required so that we can withdraw our.
When was it disposed of?
It was disposed of, Your Lordship, on just
February
5th.
2025.
Yes, Your Lordship. Yeah. No, I feel late. Okay.
You have not mentioned the date of the judgment.
Date of judgment is, Lordship, we have the judgment copy. Your Lordship, the judgment is of 5th February 2025.
The learned advocate representing the respondent insurance company submitted to have filed an application being CAM 3 2025, which inter alia stated that the name of the appellant insurance company being Liberty Videocon General Insurance Company Limited has been replaced by the name Liberty General Insurance Limited. And sought for amendment of the cause title of the memo of appeal. Full stop. In the instant appeal, the judgment has already been pronounced on 5th of February 2025. The department is directed to amend the cause title of the memo of appeal, considering the name as mentioned in annexure A attached to the CAN application being 3 of 2025 wherein the name of the company had been, name of the appellant insurance company had been changed from Liberty Videocon General Insurance Company Limited to Liberty General Insurance Limited had been certified by the Office of the Registrar of Companies. Accordingly, the department is directed to issue the you had to
refund of certain amount. They have been paid. The amount which is that
accordingly the department is to disburse the balance amount in favor of the appellant insurance company as amended on as amended.
deep.
Can 3 of 2025 disposed. Next.
For the appellant insurance company, this is there is an application for stay and also.
So you will file, thereafter obtain stay. Stay will be absolute, and thereafter you won't come. When this has been your trained.
No, madam, today only it came.
Yesterday you were not there. You took advantage. You could have appeared online. You had so many matters. How many days delay?
Nine days delay, my lord.
46 days delay. Paragraph 3. You have filed a copy of the challan. 4 weeks, issue notice, file affidavit of service. Next date, 28th of October. Next.
For the appellant. Copy of the challan, my lord. There is no delay, my lord.
Acha. Now in this matter, you had given an undertaking, but the department has not noted it. You come at 2 p.m. শান্তনু এটাতে ওদের কালকে যেমন লিখে
To my lord, there is a delay application that it has not arrived, my lord.
no, in this matter also that undertaking is there, so let them give a notice.
PM, my lord. I'm grateful, man.
23. Number 23, by my lord, last order, my lord had directed us to file a substitution application. My lord, we could not prepare it, my lord. If my lord kindly gives you a week's date, my lord. so that we can come back, my lord. The client not come, hence it could not be prepared, my lord. A week's time, my lord, is all I am praying before your lordship.
You had been given sufficient time earlier also.
My lord, yeah, a week's time is all I am praying before your lordship. Kindly gives us that. A week's time, my lord. It's all I am praying before your lordship.
One
That's since 17th of April, they are doing this.
My lord, can it be?
and no, once a question raised, my lord, and it fell from your lordship also, that whether the applicant number 2, he signed the vocal on the vocalatnama or not. So ask him to ascertain. Now, without my lord giving the answer to that, thereafter Malay said that he has to file a fresh application. But he has to come up with the application.
My lord has given that direction by my lord's last order. My lord, I'm praying 1 week's time. It's an earnest request before my lord. I'll kindly grants me 1 week's time, my lord.
On the prayer of learned advocate representing the petitioner to comply the order dated 10/7/2025 passed by this court. Next date be fixed on 7th of August as last chance. Failing which necessary orders will be passed.
It is the lordship. That matter of a dismissed BSF official. On the last occasion, Milord, we have covered up to the firing incident, Milord, and Milord, he was suffering from major depressive disorder. Those materials have placed before lordship. The doctor's evidence, medical prescription. Now, but today, I will address your lordship on what happened thereafter. Milord, the investigation and the trial. Now, Milord, the BSF has got their in-house, Milord, statutory investigation procedure. It's quasi-criminal in nature. Now, lordship kindly says how they have complied with the statutory provisions, Milord. Lordship kindly takes up, Milord, the Border Security Force rules, Milord, once.
এখানে আছে ওপরেরটা
Milord, this is chapter, Milord, Border Security Force rules, chapter 7, Milord. Investigation and summary disposal.
Chapter 7.
Chapter 7 of the rules. Rule 43 says,
Yes. Offense report.
Yes. Milord, 44, they issued a charge sheet where it is alleged that an officer or a subordinate officer has committed an offense punishable under the Act. The allegation shall be reduced in writing in the form set out in Appendix 6. Milord, this is the charge sheet. In which form they gave me the charge sheet first. That is at page 60 of the paper. Milord, 45 your lordship will kindly omit because I am not an enrolled person. Enrolled person is, Milord, the apprentice and all those things. Then lordship kindly comes to rule 45B. 45 capital B, hearing of charge against an officer and a subordinate officer. Milord, I am an officer. The charge against an officer or a subordinate officer shall be heard by the commandant. So commandant is my immediate superior. Therefore, the charge against me after the charge sheet shall be heard by him. It's mandatory, Milord. It says shall. And it's a penal provision, so it must be construed as, Milord, binding and mandatory. Then, Milord, 45B 2. Sub-rule 2, Milord. I am not troubling your lordship with our provision. It should be heard 2. After hearing the charge under sub-rule 1, the officer who heard the charge may, dismiss the charge, or remand the accused for preparation of a record of evidence. That is ROE, record of evidence. Now, my lord, if your lordship kindly turns to page 60 of the paper book,
Yes.
lordship will kindly come to, my lord, the last portion. It appears that this Rule 45B procedure has been totally, my lord, skipped. My lord, to prove me wrong, my lord, they should produce the records, my lord. I have not found anything in the records, my lord, regarding compliance with Rule 45B. They say, my lord, page 60, last paragraph, the ROE, my lord, the record of evidence, proceedings duly complete in all respect, be submitted to the undersigned by 18 September for taking further necessary action. This order is passed on 11 September. Lordship kindly sees A.K. Jadhav, 11 September. Incident of 10 September. 11 September, my lord, they're ordering record of evidence, and this is to be completed by 18 September. So there is no mention of rule compliance with Rule 45B, hearing of charge by the commandant. Because after the hearing of charge by the commandant, my lord, here is the question of natural justice. He might dismiss the charge, or he might remand the accused for preparation of a record of evidence. Here, my lord, he is remanding me for preparation of record of evidence, the next stage. So therefore 45B stage is over. So I do not know how they have complied with section for the Rule 45B. My lord, record will speak for itself. Then, my lord, lordship kindly comes to record of evidence, ROE. My lord, here, my lord, really speaking, the gathering of evidence starts under the BSF Act when an offense is alleged and charge sheet is filed. Record of evidence, this is very material. I'll show to your lordship, my lord, this record of evidence later on used in the trial against me. The record of evidence. The officer ordering the record of evidence may either prepare the record of evidence himself or detail another officer to do so. Here, my lord, the officer, my lord, ordering the record of evidence is the commandant. He, my lord, authorized somebody else to record the evidence. He didn't do it himself, somebody else. This is my admitted fact. Then, sub-rule 2. Witnesses shall be given their evidence in the presence of the accused, and the accused shall have right to cross-examine all witnesses who gave evidence against him. My lord, here the question arises whether, my lord, when the evidence was recorded, as an accused, I was fully within my senses, my lord, to defend myself or cross-examine the witnesses, because the doctor says that I was still mentally infirm.
So when were you called to record the evidence?
On, my lord, the 12th September. It started on 12th September, ended on 18th September. All through, I was under medical supervision and treatment, and the doctor said, my lord, kindly look at the doctor's observation regarding my mental condition. Lordship kindly turns to me, lord.
Now, this order issuing the charge,
Yes.
it was in the month of September 2007.
11 September.
11 September.
Just the day after the incident. The incident was on 10 September.
11 September, thereafter.
He says that let the record of evidence be completed by 18 September. It really started on 12 September. The record speaks for itself.
The next page, 61.
Yes, my lord. 61. 61 is the constitution of the General Security Force Code, where I was, my lord, sent for trial
So that
after the
was
record of
on, that order was signed on 9th of January 2008.
Yes, that's right. But record of evidence was, my lord, immediately after the incident took place on 12th of September. And on 12th September, I was yet to fully recover. That the doctor's evidence will speak for itself. I'm drawing lots of attention to that. But the doctor examined me. Exactly, my lord, the evidence of the doctor, the BSF's own doctor who examined me, my lord. What is he saying? What is my mental state? Whether, my lord, I could fully, my lord, defend myself by way of cross-examination. whether natural justice, my lord, could be said to have been complied with. What is the great hurry in ordering record of evidence? The trial started in the month of January. Record of evidence immediately thereafter, when I was yet to be released from the treatment, my lord, as under medical observation, as being regularly produced before the psychiatrist. The record will speak for itself, my lord. Doctor's evidence is there. Here, my lord, classifically turns to the attending doctor's evidence, my lord, once, my lord. Very short evidence. What center the
So that we have seen earlier also.
No, no, no. This on I have not placed, my lord. I have placed the evidence of the doctor who examined me on 10 September. But then, my lord, after the incident, which doctor, my lord, examined me, and during the time his record of evidence was continuing, which doctor has examined me, and what was his view?
Which page?
184. Relevant at 193.
Yes, sir, I have marked it. I've been treating the patient, namely Shri Amit Revar, present in the court as accused since July 2007. I examined the accused first time on 24th July 2007 and endorsed my remarks. I examined the accused and found that the patient was very much anxious, depression, and having suicidal thoughts. And finally, I diagnosed the patient suffering from MDD. Accordingly, advise handling of arms strictly prohibited.
Yes.
I also advise that the patient should be kept in a hospital, preferably base hospital, Kadamtala, as an indoor patient. So I have
Lordship can turns to page 189. Dr. Bharati Sen, another doctor, my lord, who was the attending doctor in the hospital.
Yes, this is also marked at about 16:30 hours on 10th of September 2007. The accused was brought before me by Shri Ajay Kumar, DC 39 BNSF. Accordingly, I examined the accused. At that time, the accused was in depression and tachycardia, state of high pulse rate.
Yes.
Thereafter, next page 190, the accused was not admitted at CH such and such and brought back for the advice of psychiatrist. So these parts are there.
Then, my lord,
As per my observation, on 13th and 14th September, the accused was depressed, slow speech, abnormal belief that someone killed me, sometime confused, insomnia. On 15th September, irrelevant talk, and on 16th September, not talking with anyone.
Pulse rate of accused
Pulse
remained
rate.
100.
As
above
per
on
my
date.
observation, I prepared the observation report.
Tachycardia, as per my observation, paper observation report. My lord, this is the state of the accused, my lord, still not fully recovered. And my lord, Lordship will looks at the evidence of the psychiatrist. This is the doctor, my lord, then psychiatrist evidence who examined the accused on 12 September. The day of starting of the, my lord, this record of evidence. That is, my lord, Dr. Nirmal Behra, page 182. 182, the first witness. 182. Has the Lordship got it? 182?
Yes.
The last pair.
I have been serving as associate professor.
Military, his qualification is Associate Professor in Department of Psychiatric, North Bengal Medical College, since September 1998.
He also said that he was suffering from major
Not only that,
depressive.
Milord, he is a specialist. Milord, he says, I did my MD Psychiatric from Kolkata University. He is a PhD Psychiatric from North Bengal. He's a specialist doctor in psychiatry and psychology. Milord, then next page, 183. I have examined the patient, namely Dr. Amit Revar, on 12 September, day when the Milord ROE started. I have detailed mental status examination of the patient that day. He was severely depressed and was suffering from major depressive disorder, MDD. Milord, in this, আমার কথার মাঝখানে বলবেন বলুন বলুন
Can I take part? Next matter is mine.
Sir, this cannot be accepted. Yes, sir.
Sorry. Milord, he says, here's the view. He's really speaking, reiterating the view of another specialist. He was suffering from major depressive disorder on 12th September when the ROE started. After examination and prescribed only psychotropic medication not to handle firearms. Keep the patient under close observation and also advise rest for 7 days. The rest for 7 days. Still, Milord met to appear in the ROE where Milord he was supposed to cross-examine the witnesses. And Milord make a statement in his defense. This is the state of affairs. Now, Milord, this ROE is completed. 7 days. Milord, then next paragraph, I'm sorry, I'm obliged to my learned junior says, Milord, to point out the last paragraph. 7 days rest advice by
Yes,
me.
sir. He was
means
asked
complete.
not to handle or free firearm as it can be dangerous to the patient as well as others. All these things have been there.
I have placed. Milord, only I'm placing the last paragraph of the 7 days means. Has your lordship got it, Milord?
Yes.
That paragraph. 7 days rest advised by me means complete mental and physical rest. This is very material, Milord. Complete mental and physical rest, Milord. Lordship will interpret what does it mean. 7 days. That is on 12th September. ROE started on 12th September, completed on 18th September. And 7 days takes me to 19th September. So throughout the period, Milord, that means complete mental and physical rest. Milord, this advice was, really speaking, ignored, disregarded and bypassed. And Milord, they, in hot haste, they continued the ROE, which was, really speaking, a travesty of the procedure, Milord, followed by them. Milord, this is as far as the ROE is concerned. Then, Milord, what has happened, Milord? Lordship kindly turns to page 60 once more. This ROE completed, record of evidence, then page 60. I'm sorry, 61. Next page, 61. In 61, Milord, 9 January 2008, ROE completed. Obviously, Milord, ROE is considered by the authorities concerned. Then they thought that on the basis of the ROE, I should be, Milord, placed before the General Security Force Court for a regular trial. I should not be exonerated, but I should be placed before the regular Security Force Court for regular trial. Because what the officer could do, Milord, had I been able to represent properly, Milord, what the officer could have done, Lordship kindly comes to Rule 51A. Disposal of case against an officer or a subordinate officer after preparation of record of evidence.
51?
51 capital A. Milord, had it been done under normal circumstances, then 51 capital A, what could have been my, Milord, benefit or remedy? Lordship kindly comes to 51 capital A. Had it been done normally, Milord, where an officer has been detailed to prepare the record of evidence or abstract thereof. Where an officer has been detailed, Milord, the officer is given the charge to prepare the record of evidence. He is the, Milord, in charge of recording the evidence. He shall forward the same to the officer authority who ordered the preparation. So after preparation, he'll forward it to the higher officer. Then, Milord, 3, sub-rule 3. The officer or authority mentioned above, after going through the record of or abstract of evidence, including additional evidence, may dismiss the charge after recording reasons therefore. Well, this possibility could have been there. Had I been able to represent my case properly and cross-examine the witnesses, Milord, this eventuality could have arrived, Milord, where he would have dismissed the charge of the recording. Or, Milord, then be 4. Apply to a competent officer authority to convene a general security force court for the trial of the accused. So if you thought that it is a case not fit for dismissal, then straight away proceed for trial. But, Milord, obviously, I was, Milord, precluded from getting the benefit of this provision because of my mental condition. Because everything was done in abnormal circumstances, knowing full well that I was not fully prepared to face the record of evidence. And to cross-examine witnesses, when almost will have placed myself in the position of defense counsel to cross-examine the witness. And this is very material because though in the trial witnesses were examined once more, but still then Miller started from the record of evidence. This is also, Milord, in the nature of a preliminary inquiry. This is a preliminary inquiry where the evidence is recorded. And if Lordship, Milord, when the record of evidence is placed before a Lordship, Lordship will find, Milord, how many witnesses have deposed against me. They're all departmental witnesses. And whom, Milord, I was not in a position to effectively cross-examine because complete physical and mental rest. That means, Milord, I was still, Milord, turbulent.
You could not cross-examine.
Could not properly, Milord. Either I refused or I could not. Not possible. Unsoundness of mind. And Milord, Lordship kindly says in the rules.
But neither the attending doctor nor the psychiatrist in any instance use the word unsoundness of mind, sir. You were mentally and physically, incapacitated by virtue of being depressed.
Yes.
That is the MDD.
Major depressive disorder.
Yes. So that doesn't in any way refer to insanity or unsoundness of mind to have been mentioned through their report.
Milord, I know what is passing through Lordship mind. What is insanity and unsoundness, Milord.
Not that way, sir. Since you
Question is, Milord,
mentioned the word unsoundness of mind, that's why I said
yes,
that neither the attending doctor nor the psychiatrist. So either he had not been given the chance to cross-examine, or he had cross-examined. But you mean to say that since he was not in his proper state of mind, he was suffering from this major depression, he could not cross-examine to the extent he should have.
Could have under normal circumstances. Meaning there was incapable of fully, Milord, availing himself of the benefit of the rules. The safeguard which is provided to an accused in the rules, he is incapable of availing himself fully of that safeguard. This is very necessary in case of a quasi-criminal proceeding. Proceedings are smacks of a quasi-criminal nature, leading to a consequence which is also quasi-criminal in nature, which may lead to imprisonment or dispensation from service. Then, my lord, these provisions will be strictly construed, and Lordship will kindly bear in mind the conduct of the, my lord, the authorities, my lord, the PSF authorities. Heavens wouldn't have fallen if they had waited for a few more days, because the incident has taken place. They could have waited for a few more days for me to gain full normalcy of mind.
So did you seek extension of time that I'm not well, or else...
Milord, not in a position to do that, Milord. This is what I'm on, Milord. Not in a position to do what in normal circumstances.
Were you hospitalized during that period?
Pardon, Milord?
Were you hospitalized during
No, I was under arrest and I was produced before the record of evidence authorities, Milord, in that state of mind. In violation of this full physical mental rest advice, Milord, in violation which was given on 12th September, the day of starting of the ROE. At the threshold, they are being advised that full physical and mental rest coming from a psychiatrist, a specialist. And this is given with the knowledge of the BSF authorities.
So we will continue with this. Tomorrow, you will be there in court? So
tomorrow?
No.
Tomorrow we have court, don't we?
Lordship so pleases me, I can come.
Yes.
Tomorrow.
I am under a great state, Milord. Lordship can fix it tomorrow, Milord. I can
Because
come and finish.
since Mr. Lahiri will take some time We have many other matters today also in the
Yes,
list.
kindly give me this liberty in case I do not come. My junior, he will take the note
Yes,
here.
yes, yes.
Because I understand, because it will continue. Your lordship also has a great burden here.
Otherwise, there will be a break in the trend of
Yes,
trend of
Ashwin. So tomorrow, sir.
tomorrow.
Tomorrow, let it be completed so that on the next day. I can-
Tomorrow,
In the first hour.
in any ways, you must have
no,
already taken the resolution of not to pass adverse orders. Done. It's coming. Whatever. So that is implied. So, but then, sir, you will get
If both the parties are there, no question of adverse order.
Yes, naturally.
So that's
Even if I do not come, then also, I give
If
that.
the hearing continues,
that is something
order.
which you write, but reality is something different.
Much obliged.
Heard the submission of learned advocate representing the petitioner. The learned advocate representing the respondent Union of India is present. Let the matter be adjourned for the let the matter be fixed on adjourned for the day.
Adjourn for the day.
Adjourned for the day now.
Leave it will list in the list tomorrow.
No. 2nd of August for further hearing.
2nd of August.
2nd of August.
Today is 1st of August. Tomorrow is 2nd of August.
2nd of August.
Tomorrow, my original file may not be here. I have the photocopy because the department, they don't have any provision to.
Sir will continue, it seems.
Yes,
You
yes,
ask
in that
your
case,
junior to take note.
Yes, ma'am.
I am praying for passport. If the Ramnagar Manas are praying for the people, I want to see
My lord, normally I don't oppose. Normally I don't oppose such prayer, my lord, but today I'm hard pressed, my lord. Different content matters, a different code. My lord, may it be adjourned, my lord, for the day.
Tomorrow both of you will come.
Tomorrow, my lord, actually, I'm in bereavement, one of my close relative died. I had to go there. The Monday, my lord, I have to.
No, sir. The list is getting lengthier. 2 p.m. I have other matters. So you please be there. They will start, it seems.
There was a direction upon my learned friend to serve the deputy opposition. Lordship, that has not been served.
Yes, sir, you haven't served them.
That has not been served. I have served the David because ordered Lordship. I have served them, but opposition has not been served.
My lord, reply, my lord,
Lordship, kindly says the order dated 23rd of December 2024, Lordship. Here the learned advocate representing the respondent, WPCA is to serve copy of every document to the learned advocate.
my lord, they have used reply, my lord. Had there been no, my lord, opposition, my lord, how my lord, reply could come?
Reply no.
My lord, I have received, my lord, reply from them, affidavit reply.
Sir,
my lord, I can supply, my lord. Yes, my lord. Today itself I will serve. Today itself I will supply.
Let them serve a copy of the opposition.
You have sought for a passover. I'm giving you a passover. Ask your senior to be here as early as possible. Next.
May I take inspection of the original, my lord?
Originally, in that case, we cannot give for inspection. We can give it to your lordship, my lord. Because it is only specially by the order of the DC, we have to bring it here.
In presence
It
of
has
my
been
learned
placed
friend.
on record. Have you?
It is with me. I can place it before your lordship, my lord.
Oh, what is the afraid of? Shall I tamper with the original?
This is their departmental order. I cannot.
Order
Was
cannot
there any
supersede the
order
order
for
of
you
court.
to submit it in the court?
Give them, my lord.
If there was any order to submit it in the court.
Yes. Earlier order, my lord, to bring the original before the court at the time of hearing. So therefore, my lord, every day we bring it with us.
Well, generally, inspection
Emergency,
is
my lord,
given of the
India
original
with
records.
your lordship, with my learned friend, with me also. We
This-
are acting on this.
I don't know, just classified secret. They can give the original presence of my learned.
We'll see that on the next page, sir. Next.
26, I am for the petitioner, my lord. My lord, earlier officer, your lordship has directed me to serve the copy, my lord. I have served him.
Where's your other side?
But I have served, my lord. Yes, certainly I have served.
Union of India.
My lord,
Just call Mr. Chatterjee. Budip Chatterjee ji.
okay. No, no, no.
Oh, Kolkata Port Trust is also a party.
Lordship.
So who are the answering respondents? Kolkata Port Trust.
Lordship, Kolkata Port Trust.
Where's your senior? He was there.
Lordship, he went to court number 759, my lord. Lordship. My lord, then kindly short pass over the matter.
You ask him to come.
Lordship. Okay.
I am for the petitioner.
Lord, I appear for the respondent.
Affidavits are complete in this matter. It's a very short matter regarding the fixation of the pay scale and the payment of terminal dues. The petitioner has retired in 2007 on the basis of the provisional pension. On the basis of the provisional pension. Now the retirement dues are to be finalized on the basis of the finalization of pay scales. But what has happened, the petitioner, this long and short of the story is the petitioner was appointed as telephone operator in Farakka barrage. Subsequently, she was appointed in Indian Museum. She continued in Indian Museum till the retirement. In the meantime, there have been circulars and orders in her favor saying that she will be governed by the circulars and orders of the Post and Telegraph Department. And Indian Museum said, yes, that circulars will follow. Subsequently, the government has given the promotion on the basis of the clerical grade to her, like lower division clerk, upper division clerk, head assistant, like this, the promotion has been given, which has been objected to by my client. After that, she has retired. This has to be decided whether she will be governed by the circulars as she is relying on, or the government which the government has given. That is the sum and substance of the matter.
Now, who has issued the circulars?
Circulars, central government has issued. Lordship will kindly see the petition.
Which page?
Lordship will kindly see page 32.
Yes.
This is the order by the Indian Museum, Director Indian Museum. The last line, her promotion will be according to the Post and Telegrams Department's rules. Then my lord kindly sees next page 33.
No, you read it in entirety, sir.
Page 33.
32. In accordance with the orders contained in Government of India, Ministry of Finance, Department such and such, and as approved by the chairman and reported to the Board of Trustee, item 3 of the minutes of the meeting held on 18/4/75, no promotional avenues in the recruitment rules of the Indian Museum for Tripti Sinha, telephone operative, or will be.
Her promotion will be according to the Post and Telegraph.
So where is this item 3 of the minutes? And why was it not considered?
Well, I'm placing the other documents. Similarly, kindly sees page 33. Similar order.
What do they mean to say? Because she was earlier in the she was inducted in the office of Post and Telegraph Department.
She was appointed in Farakka barrage. Then she was appointed in Indian Museum.
And then how come this Post and Telegraph Department rules are mentioned here?
Only because there is no promotional avenue. That is why this order was passed. There was a resolution of the Indian Museum. On the basis of that.
Where is that resolution?
Kindly sees page 33.
33?
Yes.
It's illegible in continuation with the.
In continuation of the office order number TO number 12/75/76 dated May 22, 1975. Just the previous page your lordship has just now considered. The duties of Srimati Tripti Sinha are fixed
Type
hereby.
copy, sir. I mean, is this kind of copy that you annex? Anyway, read it out.
Yes. Srimati Tripti Sinha are fixed hereby as telephone operator with additional work of typing, diarizing, and similar other works in the administration section of this office, as and when required, including telephone supervising. Her promotion will be regulated on the basis of seniority and other provisions of the rules as obtained in the
Now,
Post and
did
Telegraph
Indian
Department.
Museum
Director.
adopt this post and telegraph department rules?
No, no, in her case, it has been given. This is the government order, and
No, is it the general practice? I mean, do they have their own rules or they have adopted this rule that has to be that has to be checked into?
no, no, India.
Why, in her case, she was to be governed by this rule?
So far, I have come across these papers. In the affidavit, the government has not disputed this stand. Government has said she has been given promotion on the basis of the clerical grade that has been given. But government has not disputed these orders and this stand. I'll place that. Then Lordship kindly sees page 34. The Post and Telegraph Department, Office of Director General, Post and Telegraph, New Delhi.
Yes.
Number 171 NCO dated 17th December 1983. Agreement between official side and staff side of Post and Telegraph Department Council of the JCM regarding introduction of one-time bound introduction regarding its implementation. There is one-time bound scheme. The following instructions are hereby issued in connection with the implementation of the time-bound one promotion scheme in the Post and Telegraph Department. 1. The scheme will come into effect from 30th November 1983. All officials belonging to the basic grade in Group C and Group D, to which their direct recruitment either from outside and or by means of limited competitive examination from lower cadres and who have completed 16 years of service in that grade will be placed in the next higher grade. The officials belonging to the operative cadres listed in the annexure A2 to this agreement will be covered under the scheme in the telecom wing. Next 2, the head of the circles or districts or divisional engineers will take immediate action to identify officials who have completed 16 years of service in the cadre covered under the scheme as on 30th November 1983, as well as the officials who will be
She was a telephone operator?
Yes, she was telephone operator. Now, when the circular came, she was eligible for this scheme. She completed 16 years. Head of circles convened departmental promotion committee meeting to consider promotion of the officials in the operative cadres to the next higher scale of pay. The department promotion committee, which will be constituted in accordance with the existing instructions applicable to the different cadres, will advise the fitness of the identified officials for promotion the higher scale of pay. The formalities in this regard should be completed within a period of 3 months. The promotion to the next higher scale of pay will be granted from the date following the date on which the identified officials completed 16 years of regular service. In case of officials who have completed 16 years of service before 30th November 1983, the promotion to the next higher scale of pay will take effect from 30th November 1983. Then the other parts, the next important part is the petitioner is scheduled caste candidate. the clause 5 is applicable to her. Implementation of Supreme
So
Court.
you get a typed copy on the next date. Will you be relying on page number 36 in any ways?
Yes.
Is it legible?
The type copy is there. Next page is type copy.
Yes. Now, what is your case?
My case is that this particular 17th December 1983 order, this is applicable to me in terms of the resolution or order of the Indian Museum. Then subsequently, if your lordship kindly considers page 44, the order of the Undersecretary to the Government of India, this is by Human Resource Development Ministry, Department of Culture, addressed to the Director, Indian Museum. Representation of Srimati Tripti Sinha, telephone operator, for placement of higher grade of scale of rupees 425,640 regarding. Sir, I am directed to say the representation dated 20th January 1991, addressed to the Secretary, Department of Culture by Srimati Tripti Sinha, telephone operator, Indian Museum, Calcutta. This department to examine the same.
Now, in view of the position that the case of Srimati Tripti Sinha for upgradation is covered under circular
Dated
such and such
17th December
of the
1986. So that
Director
is being
General.
relied on. That page 34, that particular circular is
So
being
did
relied
they give effect to this?
No, they did not give. They have given a different set of promotion or pay scale.
Where is this circular?
This circular just now I placed before your lordship.
So you mean to say that clause 2 that you read over there was not
yes.
given effect to?
Not given effect. That is my case.
When did you retire?
In 2007. Date is.
When was this writ petition filed? 2010.
In 2010. Retired in 2007.
What did they say in the affidavit in opposition?
28th February.
Did they file any affidavit in opposition?
Lord,
we filed an affidavit in opposition.
So there's a specific order.
Lord, I will have to take some instructions on this, my lord. Lord, allow me to come back. And with the recruitment rules, my lord, because the recruitment rules have not been annexed as a part of the petition.
So at the time of her retirement, you will say that the recruitment rules are distinct. At the time of retirement.
No, my lord, this correspondence between the parties has been going on since her appointment. My lord, the case of the petitioner is that she will not be governed by she will be governed by the Postal and Telegraph Department promotional
How
avenue.
can she on her own instance dictate that this will be done and that will not be done?
Government departments, my lord, if your lordship kindly takes up my affidavit.
This is your contention.
Yes, my lord. Lord, because
I mean, not yours. It has been there in the memorandum that has been read out that she will be governed by this post and telegraph rules, department rules.
Yes, my lord. On this point, my lord, I was seeking time, my lord. That how can this be for a one-time case, my lord? Because the recruitment rules do not allow promotion, which has been stated in the petition itself. So, my lord, with respect to this aspect, that how can
you have to see first of all whether she was exclusively inducted for the Indian Museum or not, but she was working in Farakka Barrage as was submitted, and thereafter she was posted at Indian Museum
in 1969.
Appointed or posted, sir?
In petition,
that also you don't know. You have to find it out, because this order dated 15th March 1991 is absolutely clear as far as her position is concerned and as to how her promotion is to be determined.
And my lord, subsequently, my lord.
But they are saying you have acted otherwise in consonance with some other rules. Why have you done that?
Lord,
where is the explanation?
Lord, I will have to ask the department.
Only one thing I would like to add, Lord, sorry to interrupt. This particular document which just now I placed, the letter of the Undersecretary of 1991, that has not been denied in the affidavit.
When was the last date? You had adequate time to go through your brief, sir.
Lord, kindly give me one more opportunity, my lord. And I shall come back with the rules as
আসুন। Heard the submission of learned advocate representing the petitioner at length, as well as that of the respondent number 1 and 2. Next date be fixed on 22nd of August for further hearing. And you get yourself abreast.
grateful, my
My lord, instead of 22nd, may I come back on 21st or next week, my lord? 22nd, I have some difficulty.
Then 21st.
21st, deeply obliged.
Yes, sir.
I'm for the respondent, my lord.
Was it a fixed for their filing opposition?
They have given you a copy?
No, not given. Just given, my lord.
So will you be filing affidavit in reply to this?
I will not, my lord.
You won't. Affidavit in opposition filed by the learned advocate representing the respondent. CISF.
My lord.
Respondent CISF be kept on record. A copy of the same has been served upon the learned advocate representing the petitioner who declined to file the affidavit in reply. The petition is ready for hearing. Next date be fixed on 2nd of September, sir.
He will not appear for the petitioner. There is a fault on my part because on the earlier occasion, your lordship was pleased to direct me to serve fresh copies on the respondents. It was made ready, but my clerk did not send it. Kindly give me 1 week time, my lord. I shall serve
It
and
seems that
I shall serve and come. Initially, there was a direction for filing of affidavits, but nothing was done, and it is a matter of service under the judgeship of Purbo Medinipur.
who are the respondents?
State is respondent, and the district judge Purbo Medinipur is one of the respondents.
Acha, likhun. The learned advocate representing the petitioner is present. It was fixed as last chance also on the earlier occasion. There also you didn't turn up. Just because
On several occasions, the petitioner has
you
been-
did not turn up, sir. Do you want me to read out the number of dates to you? You didn't appear. The register administration LOM is to serve the office of the register administration LOM is to serve notice upon the respondents intimating the next date of hearing for proper representation of the same before the court and file a compliance report to that effect. Next date. Which district is it?
Purbo Medinipur.
Next date be fixed on 3rd of September. Copy of this order be communicated to the office of the Register Administration LOM. Next.
I mean, for the respondents.
Petitioner before the original petitioner before your lordships was the widow of a driver who his husband served in the cantonment board, Barakpur cantonment board. That the original writ petition died, the daughter has been substituted. The subject matter of dispute that the petitioner husband died in the year 1964 when he was in service. His wife was given the compassionate appointment in that board in Group D post. He was continuing till his retirement. In 2007, he came to know from his other superior officer that he is entitled some gratuity in respect of his husband dues. Then he made an application before the authority. The authority did not give any reply to that. Then he filed this writ application. After filing the writ applications, they response and give some amount that was with some certain period. After receiving that, he, my lord, asked for the balance amount they have given in since 1997. His husband died in 1968, my lord. Therefore, he asked for that balance amount. My lord, kindly see the first annexure of my writ petition. At page 14. This is my first application.
So the pleadings are complete?
Yes,
Complete.
yes.
Well, my main is delay, my lord. And my lord, even on equitable grounds, my lord, she, after her husband's death, my lord, her claim is that nothing was paid. Unfortunately, this claim was raised after 37 years. 37 years, first claim raised. We could not find there any records. Thereafter, an ex gratia payment was made because nothing was found, my lord. Still, till date, they say now we want pension, gratuity. Possibly, if they are praying for gratuity, they want gratuity and interest possibly. Or if they say that I need pension, my lord, he was not, admittedly, he was not covered under the pension scheme.
Now, after death of
Now, arrear pensions they are claiming. They are even not certain about their own claim, my lord. Not very certain.
How much have you received?
Well,
On what account?
that is, my lord, kindly come to the affidavit in opposition where they have disclosed a letter.
Page
16 in affidavit in opposition.
Application itself is for ex gratia.
Kindly. I have made application in 2007. Affidavit in opposition filed on my of the cantonment board.
দেখতে পাচ্ছি না।
Pension নিয়ে
লাইটটা
dispute
আছে।
ex gratia.
So the affidavit in opposition is not on record. Who is Mrs. Shoma Rai Chaudhary? Madam, you?
For petition.
Yes. But
This will be named, this will possibly.
Rituparna Mujumdar, my lord, affidavit.
Reply is there, but the copy of the affidavit in reply is there, but the affidavit in opposition is not there.
It is possibly been reaffirmed, my lord. Possibly. জমা হয়েছে
Well, possibly a reaffirmed affidavit has been submitted. A4, it will be in A4 file. ও সাইন করে দিয়েছিলাম reaffirmed properly.
Have you filed it in the department?
No, in the court, my lord. It was not reaffirmed, my lord. Possibly I had signed it and but then the honor court had allowed it. There will be it will be in the name of
Because I only find
Rituparna Majumdar. Rituparna. It will be in the name of back sheet will be in the name of
No.
Nahi.
It's no.
Then my lord is reaffirmed.
But then it has to be filed in proper manner.
Original.
So you take a week's time to file the affidavit in opposition. And sir, in the meantime,
Kindly grant me 2 weeks time.
because a Xerox copy has been filed.
Yes. The court had allowed at that time.
So you file it in the meantime, sir, you prepare a list of dates along with the heads of accounts on which you have already received and the balance which you claim you have not yet received. Okay.
As regard my lord, during my service tenure, my wife's service tenure, there is no dues. It is the dues of his husband.
Whatever it is,
Yes.
you are claiming something.
Yes.
So that claim has to be substantiated.
Yes.
You said that you have received an amount.
Yes.
So on what account you have received it? And on what account you feel that you are yet to receive?
Yes. That the period I shall give.
Not only the period.
And the account.
Yes, whether it's the gratuity, provident fund, leave encashment, whatever.
No. That they have, my lord, is stated it is the ex gratia relief. That is the ex gratia.
So do you want the relief?
Yes, absolutely.
Then where is the harm, sir, in detailing it?
I shall file.
Heard the submission of the learned advocate representing the petitioner as well as the respondent Union of India, the learned advocate representing the respondent. Sir, what is the department?
But this is Cantonment Board.
Union of India.
No, it's a separate. I will be appearing on both, on behalf of both.
Respondents is to file a reaffirmed copy of the affidavit in opposition by the next date of hearing. The learned advocate representing the petitioner is to prepare a chart with regard to the amount already received by the petitioner on account of the death of her husband.
November 9th.
As well as the benefit she is yet to receive on different heads of accounts, as well as the period of such benefits to be inured by her. Next date to be fixed on 14th of August.
Well, I should have granted me 2 weeks time, my lord. Because my lord, I know the
21st of August. এটা কত নম্বর? এই পাসওয়ার্ড গুলো যা যা আছে একটু দেখে খালি করে দাও। 25 থেকে রাখো।
But in this matter, I am for the petition. I got the change bill. In my brief, I find though we had used the affidavit in reply, there is no copy of affidavit in opposition used by the respondent.
So you use the mic?
I am for the petitioner. It is my change brief. From the brief, I find.
When were you
I find
When were you asked to represent the petitioner here in this matter?
this year only. 24th, I have got the change bill. Then
24.
24. 24th of 24, 2024, we got the change bill.
Have you filed the wakalatnama?
Yes.
Not
I
yet
have
made.
used the, my erstwhile advocate used the affidavit in reply. My learned friend also used the affidavit in opposition. From my file, I find that affidavit in opposition is not traceable or lost. As a result thereof, on my submission, your lordship directed my learned friend to hand over a copy of the affidavit in opposition so that I can assist my lord properly.
Well, today itself I will serve. Today itself I will serve.
Yes.
Well, so fix it on any day. I don't have any objection. Let it be.
For this, you were insisting. This is your submission. I thought you were ready with the matter. You will argue. And this.
Unless I go through the affidavit in opposition, how I will assist my lord?
You could have asked him earlier also. He
No,
would
I
have
have.
given
I
it.
have. There is my lord's order also. Your lordship kindly find my lord's order. No, I am not misleading the court. The lordship
Who has asked you that you are misleading?
No, no. I have submitted before on the earlier occasion. My lord directed to have a look to my lord's order dated 23rd December.
My lord,
Why didn't you give him a copy,
difficulty
sir?
is, my lord, my brief is also, my lord, other advocates were appearing, very old matter. It was
The
initially not
learned
with me, well, I have
advocate
collected it.
representing the respondent WBAC DCL is to serve a copy of the affidavit in opposition upon the learned advocate representing the petitioner who submits to have lost the copy of the same.
Yes. Well, I have lost. My friend has lost. That is, I have lost. All the similar.
Next date we fixed on 22nd of August for hearing.
Yes.
On that date, don't come and
I
say
will
that
not,
you have
will not.
lost your affidavit in reply.
No, I can't. I can.
Next.
My learned friend is saying to pay for
May fix it at 2 p.m., my lord. It's an old matter, my lord. May fix it at 2 p.m. on 22nd.
So 2 p.m. I can't guarantee. On that
But
date,
I
you
don't
come
have any
and-
objection to at any time, on any date. I will
but
not take
don't
time.
barge in when the other hearings are taking place.
No, I will not.
Next.
26, I am for the petitioner.
Yes, what is the issue? Where did Mr. Dasgupta go? I miss.
No,
Who is your other side?
other side, your lordship.
Who appears for Kolkata Port Trust's জন্য একজন আসে না? ডেকে পাঠাবে তো? Let's see. Let's find out somebody from who represents Kolkata Port Trust.
But initially, the second time,
You come at 2 p.m., sir.
2 p.m.
Next.
But I have served the board
I have
also.
seen. I have seen. Next.
Your Lordship, I am for the petitioner, Your Lordship. Your Lordship, there has been a restoration application, Your Lordship. This matter was dismissed on 2nd November 2016, Your Lordship. And the restoration application filed on time, Your Lordship. Kindly be restored this matter. On that,
Have you served notice upon your
Your Lordship,
this side?
this is a no objection brief, Your Lordship. I have
Are you the
advocate on record, Your Lordship.
Serve notice.
Your Lordship.
The learned advocate representing the petitioner is to serve notice upon the respondents along with the copy of the application for restoration of the instant writ petition which had been dismissed by the order of the coordinate bench on 12 June 2025. No,
জুন নয় ম্যাম
sorry. এটা হচ্ছে 12 June না,
সেকেন্ড নভেম্বর
5th of
সেকেন্ড নভেম্বর আইটেম নাম্বার 40 অনিমা বসাক ভার্সেস স্টেট অফ ওয়েস্ট বেঙ্গল
এই অর্ডারটা তো নেই, দেখুন।
Honorable Justice Devanshu Bajak dismiss the matter, Your Lordship.
5th of September 2017. No.
Kindly see the
matter.
page number 9, Your Lordship, of the restoration application. Kindly see.
Second of
November.
November 2016. And file an affidavit of service to the effect. Next date be fixed on 29th of August. Next.
Your Lordship, I appear on behalf of the respondents, Your Lordship. May I have the leave to appear virtually?
Report.
Your Lordship, the exception to the report has been filed. However, Your Lordship, there has been some allegations made which is pertaining to the records, Your Lordship. May I a very short leave to file a rejoinder only to the respect to the allegations made in the exception, because it pertains to some records, Your Lordship. I have to deal with that before the hearing. If Your Lordship grants me a leave.
I will fix it up for hearing.
Yes.
This is going on for quite some time now. Exception to the report filed by the learned advocate representing the petitioner in the form of an affidavit. You have filed this in the form of an affidavit?
Yes. It is on affidavit.
Be kept on record. Next date be fixed on 4th of September for hearing. Next.
Your Lordship, only leave in the meantime if I file a rejoinder, only that much. In the meantime, I will not ask for any time, Your Lordship. Only that much leave be given.
First you appear on 4th and let the hearing start thereafter.
As Your Lordship pleases. Grateful.
Chief, I'm appearing for the petitioner in the...
I am for the Union of India, my Lord. My Lord, pursuant to your Lordship's direction, I am filing the affidavit in opposition in this matter. I am giving over copy to my learned friend. There was a direction on an earlier occasion. The earlier learned advocate did not take steps. The earlier learned advocate who appeared for the respondents, he did not take step.
Now you have taken steps?
Yes. I have filed the opposition. I have
Affidavit in
handed over
opposition
copy.
filed by the learned advocate representing the respondents be kept on record. What about your reply?
Lordship, I'll file, although I have filed my written notes of arguments.
What about your reply? Do you intend to file?
Within fortnight, Lordship. Within fortnight. 2 weeks. I filed my written notes of argument on...
So that you must have done before the coordinate bench.
No, before your Lordship. Earlier, advocate for Union of India was appearing. He was not there at that point.
So without reply, without the pleadings, how can you file it?
February 2025, Lordship. Before your Lordship.
And you must have prepared it and you have filed it. But by that time, affidavits were not exchanged.
No, your Lordship.
Then? Can this be disposed of without filing affidavit and a reply?
No, your Lordship, I'll go through the opposition and I'll file reply, your Lordship. Just now I'm receiving the copy of opposition.
The learned advocate representing the petitioner intends to file affidavit and reply to the affidavit in opposition as aforesaid. Next date be fixed on 18th of August for filing affidavit and reply. Positively.
I appear for the respondent bank. Your Lordship, on the last occasion, I have prayed for time since the petitioner is only intending, my lord, to have his gratuity and leave encashment. I prayed for time in order to file a report so as to, my lord, I can indicate that what will be the amount of gratuity and leave encashment. My lord, yesterday only I have received the instruction by mail, your lordship, whereby they have disclosed the amount of gratuity. If your lordship wants, my lord, I can place it. If your lordship feels to dispose of the matter today itself, or your lordship, I can file an affidavit as your lordship.
You file an affidavit. In the meantime, you give a copy of what you have received.
My lord, only point is this, let me see the affidavit. My point of argument will be only on the interest. Best.
So let her file it in the
Let
form
her
of
file
an
her affidavit.
affidavit.
Last
In the
time
meantime,
there was-
listen to me, sir.
My lord.
She has given you a copy of the calculation.
Lordship.
Yes.
Right? So I'll give her a date to file the affidavit. I mean, annexing these documents. By that time, you go through this.
My lord.
And on the next date, you submit as to whether they are correct or not. And based on that, we'll dispose of this.
Lordship,
Correct, my lord.
I'm grateful to your lordship.
The learned advocate representing the respondent bank is to file an affidavit based on the report she has received from the concerned bank detailing the
amount of
gratuity as well as leave encashment.
Well, a leave encashment will not be payable as per the bank. I'll indicate in my report.
Only the gratuity amount, right? Leave encashment, the
My lord,
gratuity amount.
I crave your lordship leave to argue on the point of that leave encashment is permissible and is entitled as per law. And so banks leave.
Provided you have that leave to be encashed.
Yes, certainly. Otherwise not.
কি বললাম? Which the petitioner is entitled to receive. A copy of the calculated sheet has already been served upon the learned advocate representing the petitioner for his information.
I'm grateful to you.
Next date be fixed on 12th of August.
Lordship, I'm deeply obliged.
I appeal for the petitioner.
Yes.
My learned friend.
You start.
Yes. But the present petition was initially filed challenging the orders passed by the authorities of the respondent company, my lords, thereby passing an order of recordable warning against me, my lords. Now, my lord, subsequently, and because of which my promotion was getting delayed, my lords, and was getting denied, my lord. Now, subsequent to filing of this writ petition, my lords, I have been granted my promotion. So the major.
Did you file your affidavit in reply?
Yes, my lords, everything is complete.
Yes,
Now,
tell me.
Now, my lords.
Who are you?
I am, my lords. I was initially the general manager of Bharat Coking Coal Limited, my lords, a subsidiary of Coal India, at the time of filing of this writ petition. Now, after filing of this writ petition, perhaps the respondents came to realize their mistake. They have promoted me, my lords. Now, today I am performing my duties as an executive director of Coal India, my lords. So, my major grievance with respect to promotion is already addressed. Now, the only issue, my lords, that remains is the payment of my PRP, performance related pay, for that particular period when this punishment was imposed on me, my lords. Which is
what was the punishment?
The punishment, my lords, was of recordable warning. But as per their own affidavit, in their affidavit in opposition and various circulars, my lords, recordable warning is not a punishment under the CDS rules of the Coal India, my lords. May I one by one show the documents, my lords? Let me show it from their affidavit, my lords, for the sake of convenience. My lords, kindly take their affidavit, my lords, at page 8, my lords.
Yes, which page?
Merchants will kindly take
Page 5.
Page 8, paragraph P, my lords.
Page
8, paragraph P.
Yes.
Lords, may I place it, my lords? It is stated that clause E of the office memorandum so and so issued by Coal India, being an establishment of common coal cadre, specifically provides that warning is not a penalty under Conduct Discipline Appeal Rules 1978 of Coal India Limited. Clause F of the said office memorandum inter alia provides that recordable.
So it's in the form of a censure.
It is, my lords, censure is a punishment, my lords. Censure is a punishment. If you impose censure, that is a punishment. But recordable warning is not a punishment. My lords, we'll see the next line, my lords. Clause F of the said office memorandum inter alia provides that recordable warning should not be issued, as it would for all practical purposes amounts to censure, which is a formal punishment under the rules. So if you issue censure, that is a punishment. But if you issue recordable warning, that is not a punishment. So you do not issue this recordable warning, my lords. Now this is what was issued against me, my lords.
Read this line again.
Yes, my lords. Clause F of the said office memorandum inter alia provides that recordable warning should not be issued as
it would.
Yes.
It should not be issued.
Yes.
Then continue.
As it would for all practical purposes amounts to censure, which is a formal punishment under the rules. Yes, absolutely. So, my lords, if they issued a censure, my lords, for a punishment, my lords,
Therefore, recordable warning is also a kind of a.
my lords, subject to what my lord falls from my lords, my lords. A recordable warning, my lords, is a specific punishment, my lords, which is prohibited to be granted because it is similar to censure but not censure.
That is your stance.
That is their stance also, my lords, subject to what they say, my lords. Because, my lords, ultimately for a punishment, my lords knows there has to be a procedure which has to be followed. A charge sheet has to be issued, a disciplinary process has to be followed. Nothing was done in this case, my lords.
It is stated that clause E of the office memorandum dated such and such, issued by Coal India Limited, being annexure such and such, specifically provides that warning is not a
penalty.
Penalty under such and such of the inter alia. Under such and such of the say inter alia provides that recordable warning should not be issued as it would for all practical purposes amount to censure, which is a formal punishment under the rules. Clause G therefore provides that if a recordable warning has already been issued as a result of disciplinary proceedings,
the result of discipline proceedings,
before issuing of this memorandum, it should be treated as a censure.
Mine was obviously after that, one, and second, there was no disciplinary procedure that was followed. So, my lords, it is an admitted fact, my lords. I don't think, my lords, if my learned friend would have been here, my lords, I don't think they will dispute this fact that recordable warning, one, is not a punishment, and second, it has been wrongly issued, my lords. Now, that being the case, my lords, they promoted me, my lords. Today,
so they did not consider recordable warning to be a punishment, otherwise you would not have been promoted.
Yes, my lords. That is one. Second, my lords, now that having been taken care of, my lords, the only thing that remains is the payment of my pending PRP, my lords, performance related.
So your grievance as far as your promotion is concerned has been meted out.
Yes, my lords. Now the only issue, my lords, as I stated, my lords, is regarding to the PRP benefits, my lords, that was payable to me during this period when this recordable warning was issued.
Now, did you seek for that?
Yes, my lords. They have dealt with it in their opposition also. My lords will kindly see, my lords. the next page, my lords. Paragraph S.
Paragraph
S.
Now, what is it? Where is the discussion of CIL's board?
Yes, my lords. Paragraph S, my lords, will see. As per
Yes,
discussion
office
of CIL's board.
memorandum dated 8th March 2016. Did they annex it?
Yes, my lords. My lords will see, my lords, from paragraph Q, my lords.
Where is the office memorandum?
Yes, I'll take my lords to the office memorandum. It's a large document. They have set out the relevant portion, my lords, in their previous paragraph. Paragraph Q. If my lords takes it from paragraph Q, my lords, it will be clear. May I place it, my lords? By the director, PNIR Coal India Limited, by office memorandum dated 8th March 2016, communicated the decision of the Coal India Limited board in its
Poor, inadequate fare, failed to submit PMS. Executives terminated for service, absconding, unauthorized executives.
And awarded punishment during the final year. So, my lords, recordable warning, on one hand, they are saying is not a punishment. And on the other hand, treating it as a punishment, they have not paid my PRP, my lords.
This is your only issue.
This is my only issue. Apart from that, the promotion issue I stated, my lord.
Who's your other side?
Learned.
Mr. Bishwarup Bhattacharya is appearing in this matter, Lordship. He's engaged in courtroom number 30.
He's always engaged somewhere or the other.
Lordship, I have intimated him, Lordship. If your Lordship
anyway
permits us, we can apprise you, Lordship, on the next day of hearing, Lordship.
Heard the submission of learned are you the advocate on record?
I'm not.
Who is the advocate on
my
record?
colleague is the advocate.
Yes, then you submit whatever you have to. If you're the advocate on record, you must be knowing about the stance of the respondents. Yes, sir.
Can you give us time for we will know?
What time? Today it was fixed as last chance. Heard the submission of learned advocate representing the petitioner. You have just come to give your names to be recorded in the order sheet. That is what.
The judge has earlier appeared in this matter. We have also held a conference. So, Lordship,
So what can be done, sir? Have to be praised for that?
No.
Then you have stated the amount of PRP and etc. That is.
My lords. PRP is to be calculated by them, my lords. It's an internal process that they will follow, my lords. I cannot know the exact amount. I had
heard the submission.
Always received excellent, the topmost PRP, my lords. Always. That is undisputed, my lords. So they will accordingly calculate and, my lords, inform my lords, and then appropriately.
At length, the learned advocate on record representing the respondent Coal India Limited is present, though did not submit anything to assist the court. Next state. You have anything further to say?
Also, I just wanted to show, my lords, that I have in my writ petition, my lords, where I have pleaded regarding the PRP, my lords. It's paragraph 32. That's
Next state B. fixed on 19th of August for final hearing, for further hearing.
They may kindly be instructed, my lords, to bring the amount of PRP, my lords. That will really, my lord,
They will not come, sir.
that will really help the finalize the issue, my lords.
Whatever it is.
Your Lordship, I am appearing for the respondent. 62. My Lord, report
My Lord,
already has been filed earlier.
in this matter, my Lord, I am for the petitioner, my Lord. My Lord, during the pendency of this writ petition, my Lord, one order has been passed by my Lord respondent authorities, my Lord, and my Lord, this is to be brought to be bring in the my Lord by way of
What order?
affidavit before this.
Why have you filed this
My Lord,
petition?
because, my Lord, I have filed this writ petition because of medical incapacitance. He was dismissed, the writ petitioner, my Lord. And my Lord,
dismissed on medical grounds.
Dismissed on medical ground, my Lord. And this was my Lord. Kindly let it be heard, my Lord. Kindly come to. I am the writ petitioner here in my Lord. In the year, my Lord, 16th 2011, 16 January 2011. In shortcut, my Lord, I shall not shall, my Lord. I am submitting before your Lordship the matter. My Lord, the petitioner, my Lord, appeared in the written test under the BSM, my Lord, for the post for recruitment to the post of constable, GD. Before
Which
the
year?
my Lord, the year 2011. Thereafter, my Lord, he was succeeded in the written test. Medical test was done by them, and he was employed for appointment. But since appointment was not issued by the respondent authorities, the petitioner, my Lord, filed an petition before this honorable court. And my Lord, that was put, my Lord, that was put, my Lord, and order was passed in favor of the petitioner, directly to them, my Lord, to issue the, my Lord, appointment letter. And according, appointment letter was issued on, my Lord, 6th September 2012. Appointment letter was issued by the BSF authorities, and the petitioner before your party joined in the service. In the year 2015, by
और इसके बोल रहे हैं कि कॉन्फ्रेंस कर रहे हैं
the petitioner, and my Lord, he had taken at point of time 2 months medical leave. From them it was granted, and thereafter, my Lord, he joined sometimes, my Lord, in the month of September. Now, my Lord, what happened?
So he was on unauthorized leave.
No, he was medical. It was granted by them. It is not that, my Lord, they granted. My leave was granted to him. I have stated in the paragraphs of the leave, my Lord. Now, what happens, my Lord? Kindly come to
ओके बोल रहे हैं
page 9, my Lord.
Page
9, paragraph 7, my Lord.
কোথায় পেজ 9 জি কোথায় ভাই
Yes.
And here I have stated by in the year 2015, the petitioner had fallen. He was well posted at Gujarat under the border security force. My Lord, force, the petitioner was under treatment for few days. The concerned Department of Border Security granted 2 months leave in favor of the petitioner. After recovering from his illness, the petitioner again joined in his post, my Lord, at Gujarat, and he was continuing smoothly, my Lord. Now, my Lord, the petitioner, he was treated by the doctors, etc., and thereafter, my Lord, he again, my Lord.
It is to be mentioned herein that while the petitioner was on leave, he was treated. Then, after joining, there was a regular. Okay, then.
Then, my Lord, paragraph 9, my Lord. Your petitioner states that on 25th 10, 20, 17, I no number such and such. One proposed ruling was issued by one by the commandant, my lord, of 14.
You have been declared unfit for further service in BSF by medical board assembled at such and such.
Kindly,
Offense of MD.
And yes, this board having examined number such as constable board of my lord for this documented is apart from MDE in BAP.
Bipolar.
It is my lord, according to this, my lord, major depression disorder, bipolar affective disorder. This is the meaning of.
So
And this was
you were asked to
and my lord,
compulsory retirement.
Premature retirement. He was never dismissed.
He was not
He
dismissed.
was granted with premature retirement.
Okay. Yes.
My lord, you was in the paragraph 3, my lord, was in the same letter, my lord, at page 11.
No, they asked you to, they proposed you to return.
They give me 15 days time to give the reply. And my lord, I had given the reply to them. And thereafter, my lord, kindly come to my lord, without giving any opportunity of hearing, without anything, my lord. I was suddenly, my lord, medically, they have, my lord, this major depressive disorder, and bipolar affective disorder, etc. My lord, it was, my lord, against me, my. And my lord, when I have
No, they had given you time to file show cause within 16 days.
I had given one, my lord, representation, which is at page 49, my lord, annexure P5. Annexure P5, my lord.
P4 or P5?
P4 is the, my lord, P4 is P4 also, and my lord, this is the first representation also.
P4 is Hindi version, and P5 is subject to correction from
my
the
lord, it is the, my lord,
It is the English version written to the Director General and the Commandant.
My lord.
Page 49.
Page 49.
No, you
now,
come
my
to
lord,
page 50, sir.
Lordship.
Come to page 50.
50, yes.
By the said report, I was proposed to retire from the service of BSF.
Lordship.
In the said letter, I was further directed to make a representation to such and such.
Lordship.
Receiving the said letter, I was at loss. But I made a representation to the concerned commandant 46 BSF, who did not consider my prayer.
Now,
So,
my lord, Lordship.
Where is that representation?
My lord, this is the representation made by me at page, my lord, 49 in the English version, my lord, and this is the, my lord, Hindi, my lord, script in the Hindi.
In that paragraph, you said that you have earlier communicated to the concerned commandant 46 BSF, who did not consider my prayer.
Lordship, because of that, my lord, here, my lord, if your lordship kindly come to
I am asking you, where is that communication? Where is that representation? And what did they state while rejecting your prayer?
They said me in the said letter, kindly come to page 47, my lord. This is the most, kindly come to again, my lord, annexure P3, page 47, my lord. They, my lord, said me, they directed me, you may, within a period of 15 days from the date of receipt of this communication, make a representation to the DIG, my lord. To the DIG, not to him, my lord. Not to the commandant, my lord. This is the most, my lord, it is most unfortunate that, my lord, without giving without, it's a, my lord, cryptic order, my lord, passed. Without giving any opportunity, no natural justice has been, my lord, done, my lord, in this case, my lord. No opportunity of hearing has been given to me.
He has not filed any appeal. He straightway come before this
that is
court.
comes later. First of all, I have filed the let me complete my submission. My learned friend will say, my lord, therefore, my lord, I made the representation. He is, my lord, this type of, my lord, the constables, my lord, whatever the direction made by them, that is the, my lord, commandant. He has, my lord, directed me to make a representation to the DIG BSF. And therefore, my lord, I have given it to the my lord DIG BSF, and DIG BSF kindly come to the my lord page 51, my lord.
Sir, I did not get the reply to the question.
Lordship,
You first of all try to understand what
Lordship.
I'm asking you.
Lordship,
You are Golok Ghosh.
Lordship,
You had written to Director General about BSF as
Lordship.
well as Commandant Recruitment
Lordship,
on 1st of November 2017. Come to page
Lordship,
49.
Lordship.
You have written.
Yes.
Now you have mentioned everything in the first paragraph that you had fallen ill, you went to
Yes,
Gujarat.
yes, my lord. Without
Everything you have
please,
stated.
Yes,
Now in page number 52nd paragraph,
Lordship.
you said by the said report, I was proposed to retire
Lordship.
from service of BSF. In the said letter, I was further directed to make
Written.
a representation to
Lordship.
DIG, BSF, SHQ, BSF, JSMR.
Lordship.
Not. Full
Lordship.
stop. You look
Lordship.
at that page.
Lordship.
Look at that page, sir.
Yes, sir. My lord.
Then you say, receiving the said letter,
Lordship.
I was at a loss. But I made a representation to the concerned commandant 46, BN BSF, who did not consider my prayer. I am asking you, where is that representation and what was the ground shown by this concerned commandant 46 BN BSF while rejecting your prayer?
My lord, kindly, my lord, annexure P4, page 48, my lord, if your lordship comes. See, কি লিখেছে?
So you said that your parents are sick, you are the only earning member. That is what it has been written in Hindi.
Everything as per my lord that point of time, the petitioner, my lord, a poor petitioner, what can my lord, he can write more, my lord, he is a,
This is what you have said.
my lord.
So
Now,
did they give you a formal reply? Did this commandant give you a formal reply?
no, my lord. He has what directly, my lord, what he has complied with this one. My lord, this, my lord, since my lord, the commandant, my lord, directed him to file a representation before the DIG, my lord. In the
So that you have done
that he
in
has done.
49,
Yes,
50.
my lord.
Then proceed.
Then, my lord, kindly come to page 51, my lord. This is the order, my lord. This is the order passed by the, my lord, Deputy Inspector General, my lord.
So what are the rules?
And
Under
my lord-
which rules, sir?
My lord, this is the...
My lord, so far, Rule 25 is concerned, my lord. He has been given premature retirement.
No, there must be a ground.
Yes.
What is the rule
Yes,
that you have
we have-
invoked? That you are medically unfit, your services are no longer required. So there must be a rule.
And
Yes,
my lord,
I'm
if
grateful.
your lordship,
Your lordship,
kindly
my
see the order, my lord,
just a
what he has passed.
My lord, kindly
My
see,
lord,
my lord,
actually,
25.
54, my lord. Kindly come to the impugned order, my lord. Last page, my lord.
Both persons cannot
Accept.
simultaneously submit.
একটু বলে নিই।
Either, sir, you.
Yes, my lord.
25.
25.
This is start off from the, my lord,
Subject to
30.
correction, my lord.
Now, who detected physical
The medical
unfitness?
report constituted according to the
Did he
request of the
appear?
petitioner.
Did he appear?
If your lordship kindly takes the pain to see our, my lord, exception, my lord, we have filed a report. My learned friend
My lord,
doesn't
second,
file
Sorry,
exception to the
my lord,
report.
my lord, kindly come to the impugned order, my lord. What, my lord, they have, my lord, at page 54, my lord, last paragraph.
Now you come to page 53.
Lordship.
ওর সঙ্গে বসে clarify করো, exception নেই আমার।
Paragraph 2. Opinion and recommendation of duly constituted medical board after
Lordship.
approval of IG such and such has been communicated
To the individual via this unit, such and such dated 25 October 2017 to urge anything against proposed action, if any.
My lord, I am challenging
Yes, of
this,
the
my lord,
receipt of-
report. because of that this person, my lord, is to be, my lord, examined by a individual, my lord.
Now you both of you go on with your running commentary.
Now, my lord, the impugned order, my lord, kindly come to page, my lord, 53, my lord. And
Okay. We will continue with this.
My lord, only one indulgence. We have already filed according to the order of the earlier court, my lord, exception report. That probably is in your lordship's file, my lord.
My lord,
So if my
my lord, kindly one thing I shall see, my lord, yeah, I want to, my lord, kindly come to page 54, my lord. The paragraph 5, my lord. Constable Golok Ghosh is struck off from the strength of 42 without pensionary benefit.
Yes, 10-year service is mandatory.
And
under the CCS rules.
And my lord, I am
Company
challenging,
has
my
not-
lord, this medical board's report.
We will
my lord,
continue on the next date.
lordship. My lord, one thing, my lord. In the meantime, they passed another order. One representation was made by the petitioner before them, my lord. And they have, my lord, passed an order.
He has to file
I want to put on, my lord,
has to
one
file a
supplementary
Heard
affidavit.
the submission of learned advocate representing the petitioner as well as the respondent at length. The learned advocate representing the petitioner seeks liberty to file a supplementary affidavit annexing the recent order passed by the BSF.
Yes.
And the same is allowed. Next date be fixed on 3rd of September.
My
lordship.
Next.
Deeply obliged.
I appear on behalf of respondents number 12 to 23, 12 to 24. But, my lord, before that, I should submit, I find, my lord, that an affidavit has been filed on behalf of my clients, 12 to 24.
Now, sir, who are they? Who are the?
Millard,
who are your clients? 12 to 20.
Would your lordships, Millard, give me 2 minutes time? Millard, admittedly, we at the clients, Millard, working in the subordinate courts. Now, in the post of Bengali typist come copyist. Now, from the records of the case, it appears that Millard 12 to 23, they have retired from their service after from the combined gradation list which was prepared. I was also thinking about my learned friend Millard, in order to resolve that the matter is resolved in amnesty. Now, those persons who had retired, Millard, they have also got their retirement benefits. Now, there is admittedly a combined gradation list. Now,
under challenge.
yes. Now, Millard, I only submit that I was finding, Millard, from the combined gradation list that so far the writ petitioner is concerned, he was appointed on 25/7/2012.
I have not placed my cards.
No, I just what I find from the records. I do not say anything more. Now, if he
You are the
wants
staff of
the subordinate courts
of
the learned district judge
We are the English.
of the learned district judge Hooghly.
So this matter pertains to the district Hooghly, district judiciary.
Yes.
District Judiciary, Hooghly. We are the English typist and the answering respondents are the Bengali.
How many petitioners are there?
One petitioner.
You are
one petitioner. We had several.
He is the only petitioner who is voicing his grievance.
Earlier litigations, we were there, and they have also filed separate litigations. for regularization of their contractual service. And I most respectfully submit that they are still contractual Bengali typists.
Now,
There
your
is no
grievance
sanction
is against whom?
against the alleged combined gradation list. There cannot be any gradation list for the sanction post and for the ad hoc contractual employees. There is no post for Bengali typists, no sanction post, no vacancy, no regular appointment, no interview. They were appointed for 1 year. Now, by an order of the district judge, they have been clubbed together.
How many?
The 12 in the respondent category.
Now, how are you aggrieved?
My lord,
How are you aggrieved?
I agree by the order of the district judge.
Huh.
My lord, two pillars of prayers in my writ petition.
Huh.
One is that due to the, my lord, kindly come to the, firstly, kindly allow me to place my case. My lord, kindly come to the cause title. Kindly come to the cause title.
So the pleadings are completed?
So far as my affidavit is
Only
concerned, I have given my affidavit.
Says there are three types of government.
The matter
Have you
can
filed
be
the Have you filed the affidavit in reply? He says that affidavit.
I have filed and copy, sir.
Then tell me.
My lord, in the cause title, there is the only one petitioner, my lord, fine.
Shankar Bose.
Shankar Bose, that is the English typist, sanction post, my lord, and the respondents 1, 2, 3 are the top secretary.
So 12 to
rest.
Rest.
My lord.
So they were Bengali typists.
They are Bengali typists as a contractual.
As a contractual.
1 year contractual.
And so what
there
happened?
Is no sanction post for the Hooghly judgeship or throughout the West Bengal. There is no sanction for post for Bengali typist. My lord knows better than
What is your prayer, sir? Let us see.
my lord, kindly give me the cause title first. My lord, 1, 2, 3 are the secretaries.
That I have seen, sir.
My lord, 1 minute, my lord.
He wants quashing of the.
My lord, kindly allow me to
gradation
submit,
list.
otherwise I will take my chair.
Sorry.
Otherwise, I shall take my chair. You go on, proceed. My lord, the registrar administration is the party. He was complained several times as an administrator. My lord, in concurrence with the advice of the Honorable Chief Justice, the registrar submitted a report before your lordship in the record that he will not contest.
Yes, it's a matter of the district. How come the High Court registry get involved in it?
Honorable District, Honorable Chief
Yes,
Justice
then-
advised him not to take any part.
Yes.
And the rest, the 5 to 8 are the pay and accounts department of the state. They have not filed any affidavit. They are not contesting.
Number 5
My
is
lord,
not under the statement. I will be presenting respondent 5, my lord. Of the principal accountant general, my lord. It's not under the state government, my lord.
And what about you, sir?
I am not.
Principal Secretary, Finance Department, Principal Secretary, Judicial Department, Principal Secretary, Labor Department.
7 years they are not contesting.
So have you served a notice upon the LR?
All. Several times. I have filed the affidavit of service several times. They are not contesting according to me as because they have lost their chances to file any reply affidavit in opposition, and they have chosen not to file.
Yes, now come to your case, sir.
And 9 and 9, 10 are the district authorities who have passed the several orders which are under challenge, and the rest the State Vigilance Commission, and from 12 to rest.
What is the role of State Vigilance Commission in preparation of a gradation list in a district court?
There is a corruption, I said, in the pleading.
In every matter, if there is a corruption, then the administration.
Understood.
If he
Yes.
does
The
not take
administration-
his chair, I cannot submit it.
Yes, sir.
sorry.
Then 12 onwards?
12 onwards are the Bengali contractuals for 1 year. So they were appointed under the contracts ad hoc for 1 year. and we are servicing as English typist in the sanction post.
Not we, you, one.
Along with other English typists.
So you have filed this writ petition in representative capacity?
No.
Then you are one.
One.
Yes, then why we?
We means all the English typists. My lord, this is the writ petition and the prayers are. My lord, kindly come to the prayers. At page 88, my lord. Page 88. Page 88. Prayer A, B, C. These are challenging the gradation list relating to the prayer C, page 90. Expired 1 year contractual ad hoc Bengali typist. They are not entirely for the gradation list.
So according to you, the Bengali typists,
they
were not appointed against any sanctioned post. So since they were not appointed against any sanctioned post, they could not find their place in the combined gradation list.
Not in the combined gradation list, but they cannot have any gradation list. As because there is no sanction post, there is no appointment, and they cannot have any post.
So you mean to say they were appointed for 1 year, and after 1 year expired, they should have discontinued with their service.
They remain, but their status does not in a sanction post or for any post to be.
So you mean to say they could have performed, they could have continued with their service
choice of the district
on renewal of service.
As renewal or not renewal, that is not my subject matter. I said that they cannot come in a gradation list. They have no gradation. If they do not have any gradation, then there cannot be any word combined.
Combined gradation means inclusive of the English typist as well as the Bengali typist.
They have no gradation, so they cannot come.
Sir, please try to understand what I am asking you. What do you mean by combined gradation list?
They have used the word.
They have used the word.
District judge use the word combined gradation list. It is an unheard of word.
Combined gradation list, does it imply inclusion of the English typist as well as the Bengali typist, something like that?
They have tried.
May I say one thing?
Wait, I'm asking him. Now you don't create any trouble. Yes.
What I find from the records, Millard, I had also a privilege, Millard, to appear in this particular gradation list of English and Bengali stenographers. Now, throughout West Bengal, in most of the districts, and my lords have a very vast experience, that these particular combined gradation lists are prepared on the basis of the requirement of the work. Now, I do not find that English gradation list as well as Bengali gradation list.
Nonetheless, sir, what about the post to have been sanctioned?
Yes. Now, Miller, this is absolutely in the particular domain of the particular Miller chairman of the promotion committee of the Hooghly District.
No, sir, sanctioning of post
that is being done by the government of West Bengal.
Yes, whether those posts were sanctioned
or not, that can only be, I'm grateful to my lords, this can only be ascertained by the state government. This is number one.
Government's presence is required. Where is Mr. Dhol?
And secondly, I should just only take one more second. One more second, Miller. Kindly do not take me amiss. 1 second more. Now, Miller, kindly come to the particular Miller gradation list, which my learned friend has appended in the page 165. In 165.
Sir, if it is sanctioned,
yes,
entire writ goes.
Yes.
Right? So that has to be.
That is that it goes to the root of the matter. I say nothing.
God, I'm grateful.
Sir, so you appear for them. I'll ask.
It has to be regularized.
That is what I said. But sir, you please appear.
Yes, my lord. I will.
Don't go into temporary oblivion.
My lord, one line more, there is no law.
The heard the submission of learned advocate representing the petitioner as well as respondent number
12 to 25.
12 to 25.
12 to 24. I stand.
12
12
to
to
24. And you are? Huh? As well as respondent number 5.
Miller, one
Now-
more submission, kindly
Yes,
record,
sir.
Miller, on the instructions of my client, that Miller 12 to 23 had retired from their service after getting their
learned
benefit.
Advocate representing the respondents number 12 to 24 submitted that the respondents number 12 to 23 had already retired from their service,
We have got our also benefit.
receiving the entire retirement benefits. The learned advocate, Mr. Pinaki Dhol, who generally you are here representing the state. Who
Mr. Pinaki
generally-
Dhol.
I have said that. Who generally represents the state is requested to represent respondent number
Miller, respondents number
1, 2, 3, 4 টা দেবে না? 3, but this district 9, 10 also needs to be
yes.
How can you say 5, 6? You are also you should also represent 7 and 8.
Yes.
You yourself don't know.
He is appearing
5,
on
6.
The name of the office of my client has not been included.
Directorate of Treasury and Accounts, Pay and Accounts.
Pay and accounts is under our office.
So that's what I'm saying. You said only 5 and 6.
There is one the name of the principal office of the principal accountant has not been used.
the principal accountant there can say 5.
Yes, 5 I am representing.
5, 6, 7, and 8 would fall under him. 5, 6, 7, 8.
But 7 is not under us. Treasury is not under our
Treasury then would come under the state.
state.
Hmm? Sure.
And the High Court administration should also be represented.
I'll expunge it. What is the role of High Court administration here?
I say, Miller,
No.
I do not know. I cannot understand.
1, 2, 3. Seven. And what about 9 and 10? Huh? If
9 and 10, Miller, they are also very important persons, Miller, for the purpose of deciding this matter. The district judge Hooghly and the district Saraswata.
7 plus 7. Let his appointment be regularized. The registered judicial service is to serve notice upon the respondent number 9 and 10. Who is respondent number 24?
Number 24.
Okay.
He is what?
Intimating
He
the
is
next
acting
date
as
of hearing to ensure proper representation of the same before the court. Next date be fixed on 9th of September. A copy of the writ petition along with the annexures is to be served upon the learned advocate representing the state respondents.
One humble submission, my lord.
Your appointment has been regularized.
That is, my lord. I my lord, usually appear with a junior, my lord.
My lord,
So on the next set, you bring your junior, we'll see.
My lord,
You anyway, your junior is there. And I have to ask your junior to call you. So your junior's presence is required. Otherwise, who will go and call you?
my lord, 9th.
September.
9th. I'm grateful.
Hmm.
And affidavit, if any, in the meantime, by the state.
আপনি তাড়াতাড়ি
আরে আগে ইনস্ট্রাকশনটা আনুক তারপরে
নেক্সট
কপিটা আগে দিন
আগে কপিটা রে
My lord.
আগে কপিটা দিন
So look, we filed the supplementary affidavit. This is the affidavit of service. It Amar bhi? No, this is not fine. The affidavit of service. Well, this your lordship would recall relates to paramedical workers who were apparently appointed on contractual basis. The entire issue was challenged before this honorable court by one particular candidate. That your lordship needn't be troubled with the papers now. That one particular candidate assailed the entire selection process. The learned single judge in that writ petition came to the conclusion that that writ petition did not have the eligibility criteria and therefore no locus, but the selection process was tarnished by for a certain reason that there was some deviation from the rules and whatever. That order was carried in appeal. The division bench holds that once the court returns a finding that the writ petitioner has no locus, there is no scope for any further embarkment on factual investigation after that, and sets aside that order. Now, in the interregnum, people like us who were appointed in 2014, who apparently were appointed for 1 year, from February 2014, which expires.
Health and Family Welfare Samai. Question Vardhaman.
I'm so sorry.
Number 12 herein issued a recruitment notice bearing note.
Oh,
So you ask somebody to take your phone out of the court? Yes.
14 February, which if for a period of 1 year, it would expire in 15 February. We were allowed to work till December 2015. Now, the division bench holds that what has happened in the interregnum, the authority could not show. These contract papers were unsigned. I mean, they were signed but undated. So when my period of contractual employment actually started was not to the knowledge of the court. And for how long I have discharged my services and under what condition, that was also not to the notice of the court. So the court holds that for these appointments that were granted and may not have been regularized or maybe are still carrying on, that the authority will take a reasoned decision and pass an order. After this order is passed, I'll place the division bench order. After this order is passed, a one-line order is passed by the authority, which is impugned here, saying that panel is gone, the services are terminated, we are floating another new panel, another process of initiation for selection of these paramedical workers. So two writ petitions were filed. One was assailing this discharge and my so-called termination, which is before your lordship today. The second one was assailing the second notification by which they were initiating another process to recruit further paramedical workers. When the second writ petition was filed, the respondents came and indicated that we are not going to proceed on the basis of this. So that writ petition became infructuous. That is appearing as item number 77. None of the parties have anything to do with 76.
You read out the number of the writ petition.
Yes. Well, this is what is the one that is surviving today, and the challenge is still live, is WPA 6626 of 2020. Now, the issue I had last addressed your lordship, and I must be candid, there were a lot of things that actually did not strike me. After addressing your lordship, there are certain pointers that the court very graciously gave us. We went back and did some homework, looked up the law and saw that that is probably the way we should have approached the matter. and we found certain documents, and I've made a note of what your lordship had required us to look up to advance a case a little further than where we were stuck. And those documents we brought on record by way of a supplementary affidavit to highlight that the case is slightly stronger than how we had probably anticipated it to be. Why? Is because this so-called contractual appointment was granted on the basis of the 100-point roster. Reservations were applied. Transfer allowance irrelevant. Dearness allowance was granted. The contract period was stated to be for a period of 1 year. I have worked and received salary even post that. So really speaking, these are not so much contractual employment anymore. This was actually after I addressed your lordship on the last occasion, certain queries came. Why addressing your lordship wanted us to look it up in this angle, because this really does not partake the character of a contractual appointment anymore. And I want to advance my case on that basis now also. Apart from the very hackneyed but established principle that the division bench order was not complied with, this is not a reasoned order, it was a one-line order. There is no basis on which this impugned order has been passed. There are no reasons given. All that is one aspect of it, which as a lawyer I had approached it. Now I want to take it slightly higher on the ground that these were not contractual appointments at all. The moment you apply the 100-point roster, and I'll show one particular notification, and appointments are given against the 100-point roster, and you give me dearness allowance on the basis of a particular notification, and my period is allowed to continue post the so-called contractual period, and I am discharging the same function that your so-called regular employees are discharging, then this nomenclature of a contractual employee dissipates into insignificance. To buttress this, there are 4 documents I would like to show, but first I must show the division.
You had filed that supplementary affidavit.
I have filed the supplementary affidavit, not bringing on record a few documents which will show that I've worked post the so-called contract period. The contract is stated to be for a year. My induction or grant was of February 2014. I have received salary till December 2015. And this is something that the Honorable Division Bench had taken note of to require the authority to apply themselves to what would be the initiate or the initial period of the contract, because all these contracts were they were blank. The period was not mentioned, except that I joined in February. That will be evident. And I've received.
Sir, you have received a copy of the supplementary affidavit?
Yes, we've.
I mean, my lord, 8089.
I mean,
they have stated that that 8089 has already become
infrastructure. That's my affidavit also. That has been placed on record. So let that matter be disposed of.
They have filed one supplementary affidavit in 6626.
That,
you are not appearing.
Mr. Mukherjee is representing 6626 because both the matters are together. That's why.
In 6622, we have already filed an opposition.
No.
They have filed
supplementary
affidavit on 25th of July.
626. Mr. Mukherjee is representing.
626. Yes. You have filed the supplementary affidavit on 25th of July 2025.
Yes, and we've served
have you?
Also,
but
yes.
he says he has not received it.
But we filed the affidavit. So, kake diyeche?
You.
It's served on the advocate record. The affidavit of service shows
that. I'm not there in the next matter. I'm in the first matter.
Sir, you are there in 6626.
Yes.
So they are saying they have already served upon your advocate on record. Who is the advocate on record?
Mr. Gaurav Das.
They are representing the state, or
the answering respondents are them. Mr. Mukherjee is the answer for the answering respondent.
We affirmed the affidavit of 22nd April 2025.
No, that's the affidavit in opposition.
No, supplement affidavit.
That I have not received. I'm not received.
Because they
extra copy ache.
Maybe has.
I'll give him one now, my lord. Affidavit. Naughty boy, it's affidavit of service. No, I don't have a spare copy, my lord. That
So
let
give
him
him a
take it from
copy.
my let him take it from his advocate on record, who has received it. আমার কাছে আছে।
But so far as the
I'll give
past
mine.
matter is
I'll give-
concerned, your lordship may be relieved
No, no.
by disposing of this matter because nothing remains.
Actual submission. In that matter, 8-8, when my learned senior friend is appearing, there is an injunction, which is why they're not proceeding. The moment I withdraw that, the injunction will be free and they'll proceed against.
It has been dropped. And I've said on oath.
Let that remain, this under challenge. If they've recalled it, then so far they've not issued
Kindly have a
another.
look to the prayer, page 61. They have questioned the recruitment notice dated 28th of September. This has been dropped, page 61.
In any case,
I'll give him
if
my copy, for the
you-
number of times I've had his lunch. I'll give him my copy for
Kunta,
Ashwata,
supplementary affidavit.
So that I can
so that I can record it. So on the next date, the question of losing it once again will not arise. Or
for file an opposition to the supplementary affidavit.
the supplementary affidavit filed by the learned advocate representing the petitioner in WPA 6626
Yes,
of 2020 on 25th of July 2025 has been served upon the learned advocate representing the state respondents.
Yes.
State respondents.
Malad, no. But in 8089, I'm there.
6626, he is appearing.
I'm still responding. Respondent 1, 2, 3, 1, 2, 3, 4, 5, 6. 7.
You can't appear?
I appear in the 8089. Here, Mr. Mukherjee is engaged in the next part, 8667.
I'm for the respondent. Respondent.
Now you have received it. You will file an objection to it. The learned advocate representing the state respondents intends to file an affidavit in opposition to the supplementary affidavit as aforesaid, and the same is allowed. How long will you take to file?
2 weeks.
Next date be fixed on.
Well, I'll take a week to deal with that, to give a reply.
Next date be fixed on 20 August
Very good.
to file the affidavit in opposition. Affidavit in reply, if any, to be filed by 8th of September.
But may I just pray for one thing?
8th of September.
He wants it till the 15th. I'll give mine by the 22nd. He wants 2 weeks to file his affidavit.
They have given him 20. 15th, he won't do it. He'll again come and seek time. So I have given him.
And Your Lordship has given me time till the 27th.
No, I have given you time till 8th.
I'll take the 27th.
27th?
I'm under a lot of pressure to trouble
Okay.
Your Lordship.
Next affidavit in reply to be filed by 27th of August. Next date be fixed on 2nd of September. For
Very good.
So far as the other matter is concerned, your lordship is not.
Let it be on board, my lord. We're not moving.
Sir, I have not gone through the records today. Next date, you just indicate.
The affidavit of in opposition has been filed.
So look it up. If it's spent its force, then I'll not unnecessarily keep it.
Yes.
I'll also
Spent its force I have placed on record by an affidavit.
Very next matter, Malad, is item number 80. But in the second of Malad, there is a contempt matter fixed at 2 p.m. before court number 37, Malad. If your lordship.
Which matter?
Item 80. Very next matter. Malad,
Who is the other side?
Malad, Mr. HON'BLE is appearing on behalf of the petitioner, Malad. I'm filing my affidavit in opposition on behalf of the private respondent, Malad. Respondent number 426, 8 to 11 and 13.
Nobody is appearing for the petitioner? So I'll take it.
Then your lordship kindly calm it.
Other matters from 2
Malad,
onwards.
any day, Malad.
Any 3:30 today?
That is why, my lord, I was wondering.
I was not aware of.
3:30 is there.
Anyway, I'll come back at 2.
Malad, then
Shall
your
come
lordship.
back, Malad?
Oh, yes.
Then your lordship kindly fixed it another day, Malad. Then 80.
চিফের একটা matter।
Takes up any other matter, my lord. I seek kind indulgence, my lord, with regard to item number 57. Please take it.
Now today, now at this point of time, original side matters are taken, sir.
Second, my lord, I go and Mr. Gupta, learned senior advocate, my lord. He is unwell, my lord. His son has left the court and he has intimated me, my lord, to pray before your lordship, my lord, intimating the situation, my lord, under compelling circumstances.
Which matter?
Item 57.
You ask any one of your juniors to be here? Next.
Item number 1.
Sorry,
Person to my lords, yes. Well, person to my lords, last order, my lord, the draft sale deed, my lord, which we had made over to them, my lord, the official liquidator has settled the draft. We have received the draft. Only thing now remains, my lord, is the execution and registration, my lord. So we could not do it in the meantime, my lord. My client is a cancer patient, my lord. There is a subsequent bout of infection again. He had to be in Hyderabad for a considerable period of time. I'm only paying for 6 weeks time, my lord, to complete the registration.
Lord, I have got no objection because I have.
On the prayer of learned advocate, so representing the respective parties to execute the registration of
Lordship.
the sale deed. Let the next date be fixed on 8th of September.
My lord, 8th of September. It's a
No.
maybe
22nd of September.
Lordship.
Very well.
Right.
Item number 2.
Published, Lord.
Your Lordship, for item number 2, I'm appearing on behalf of the respondents, Your Lordship. I would just indicate that the petitioner number 1 and the respondent number 1, they have passed away. It's an old matter, Your Lordship. It's appearing in the list after a long time. Last time the matter was taken up was in 2020. I am for the respondents, Your Lordship.
So somebody must have mentioned.
We don't have knowledge.
এলো কি করে তাহলে? ও আচ্ছা আচ্ছা। তাহলে নোটিশ ইস্যু করে দিতে বলে। হ্যাঁ তাই করি। ঠিক আছে ঠিক ওকে, তিনটেই তাই করে দিন। আমার অ্যাপেলের সাইডে অনেক ম্যাটার আছে এবার। হ্যাঁ
টোটালটা কি দিয়ে দেবো? লিস্ট অনুসারে দিয়ে দিন, 2 সপ্তাহ 3 সপ্তাহ পরে যেরকম লিস্টে দিয়ে দেবো।
হ্যাঁ দিয়ে দিন।
ট্রান্সফারে চলে দিন, আপনারা বুঝতে পারবেন।
ঠিক আছে ঠিক আছে হ্যাঁ
ঠিক আছে।
অ্যাপেলের সাইড
Your Lordship.
এইটি অব্দি তো। আচ্ছা 2 PM একটা ফিক্স ছিল না ওই
My lord, I'm for the respondent, my lord. Mr. Choyan Gupta actually has accompanied his father, Mr. Senior Advocate Mr. Gupta, to the hospital for checkup, my lord. So, my lord, I have
which matter?
my lord 57.
না না এটা 26 আছে না?
Lordship, 26, my lord, I have been informed by the my lord learned advocate or the petitioner to appear before your lordship, my lord. He was informed, my lord, that matter is
You
appearing.
genuinely appear for the court.
Lordship.
So you are empaneled.
Lordship.
Then why don't you appear, madam?
My lord, they have not served, my lord, that matter
But
is.
he says that he has served.
My lord, just
No, Lordship,
at 1:15 PM they have served, my lord.
this is the order. Initially, she appeared in the matter.
But my lord, before mentioning, they have not, my lord. Order dated 2011, my lord.
এটা অটোমেটিক্যালি এসছে, আমরা মেনশন করতে হয়নি, পুরাতন ম্যাটার চলে এসছে। কালকে তোমার নোটে দিয়েছি, দেখবে দেখে নাও।
আচ্ছা, the learned advocate representing the petitioner and respondent number Kolkata
Calcutta Port
are present. Let the matter be fixed under the heading to be mentioned on 4th of August. On 4th, you be there and then we'll see what is to be done.
I'm great.
It will come under the heading to be mentioned on 4th of August.
4th August.
I'm great.
Yes.
দিয়েছে।
56 तो आज के नहीं, आज 57. Oh, 2 p.m. কে আছে?
My lord, for the respondents, my lord.
My lord, I am for the petitioner, my lord. I am led by Mr. Kolal Basu.
Is it that Indian Museum matter?
No, my lord. This is my lord. Allied Missionaries. The petitioner is 100% blind, and my lord, he is a competent person in charge of the drug business run by the respondent number 2, my lord, the Allied Industries Limited. It's a government of West Bengal undertaking. So, my lord, the petitioner prayed for regularization as well as the setting aside of the termination order.
I think it was heard exhaustively.
Yes, my lord. If we, on the last occasion, we have filed our written notes of argument, and they have.
I'll just fix it up for clarification. If any, then only
My lord,
appear.
my lord, Mr. Gupta was submitting on the last occasion. Mr. Choyan Gupta was about to submit, my lord, but my lord has kept today for 2 p.m. Since my lord he's having some personal difficulty, taken his father, my lord. So my lord, kindly keeps
On
it.
the prayer of learned advocates representing respondent number 2 and 3. Let the matter be fixed on 10th of September. Next.
Deeply obliged, my lord.
আচ্ছা তাড়াতাড়ি 89 and 90 না? Huh? 79.
Lordship, I appear for the petitioner, my lord. The day before yesterday, I have been served with an affidavit in opposition by the bank, your lordship. Lordship, I am intending to file my reply thereto.
Where is the affidavit in opposition? Have you filed it?
Yes, my lord. Yes, my lord.
Where is that copy? Where is the copy?
The department, my lord. In 29 July.
Will you be filing affidavit in
Yes,
reply?
Yes, lordship.
The learned advocate representing the respondent bank has filed the affidavit in opposition, serving a copy of the same upon the learned advocate representing the petitioner who intends to file an affidavit in reply to the same. How long will you take?
Well, 2 weeks.
Next date be fixed on 26th of August for filing affidavit in reply.
Lordship,
You wanted 4 weeks. I've given more time.
Well, I needed 2 weeks only.
So fair enough. On that date,
I'll be coming with my reply, your lordship. I'm grateful.
positively.
Grateful.
Next. None appear to represent either of the parties. Let the matter be dismissed for default. Next.
Lord, I appear on behalf of the petitioner, Lordship.
Yes.
I appear on behalf of the petitioner, Lordship. There is added upon the provident fund to the reports. Lordship, the date has already fixed for hearing of the main matter.
No, the
Provident fund authorities are supposed to file a report.
You're ready with the report?
Yes, madam. Malad, the courtroom number, the market is there. I just took out a leave and then come up here.
So no one is appearing.
Your Lordship, I am on behalf of private respondent, Your Lordship. Company, Your Lordship. My director is present here.
Where is he?
There are all total 3 directors. One of them are present here, Your Lordship.
Yes, sir. What prevents you to assist the learned advocate?
My lord, we have given in a pro rata basis, my lord.
No, I'm asking them. You said that they were not assisting you in providing you with the pay slips.
Till date, we have not got out the Aadhaar numbers of the
Your Lordship,
employees.
the Provident Fund
UN numbers are there, my lord.
indicated, Your Lordship, along with the
Even,
Aadhaar number.
What the audited balance sheet is there in the report, my lord. What are the anomalies that has come out with the irregularities?
You said on the earlier occasion, sir,
Yes,
that
ma'am.
the private respondents were not assisting you
Yes, ma'am.
in providing you with the pay slips.
Total, that's the pay slip because it's an exempted unit, madam. When a exempted unit is there, they have their own board of trust, madam. In that board of trust is being managed by the company own board of trust. So whenever the amounts have been paid, those amounts which were paid to the petitioners, madam, at that time the BOT has given, the board of trust has given. Those copies of the slips, my lord, it is with the BOT, my lord. When the exemption was being taken away, even they challenged that order, my lord, that was being assailed by the our Honorable Chief Justice also. That is the exemption was being that was unexempted was holded, my lord, by the Chief Justice, my lord. In this case also, what they have to do, they have to give out the entire records to us. And the past accumulation. The past accumulation was 25 crore. They had given the detail in regard to that. In that, they have given only 16 crore rupees amount, which is being paid to us. And the Honorable High Court Justice Sampad Tupal has given a pro rata basis to be paid in. So we have been paying in a pro rata basis now. Now, if the documents are not being given to us, even
Yes,
the past
what is your
accumulations are
problem?
not given to us, madam.
Mine, let me learned senior finish his arguments, then I'll make you.
But if we don't get out the entire amount which has been stated by the past accumulation, 9 crore is still pending. Even the UAN number and the Aadhaar number, the serial numbers, whatever, there were 5,000 employees, there 3,300 something employees were there, where the entire records have to be taken into Mala. If we would have paid out the amount, we would have the slips. If the BOT has given the amount, my lord, at that moment of time, they are to be given, the slips have to be given to the Provident Fund, madam. If the Provident Fund doesn't get out the entire documents, madam, that is the reason I said the cooperation between the, because several letters have come.
Your Lordship, if I may start now, because he's
kind of
repeating now again, and I've catched my breath as well. Your Lordship, I have given a letter, Your Lordship. If Your Lordship could kindly consider, the letter is addressed to the PF authority. There is a stamp of...
What kind of letter is
Your
it,
Lordship,
sir?
this is a 13th, I know it is illegible, Your Lordship. 13th November 2024 is a stamp of the PF authorities, wherein serial number 5. If I may give a marked copy, Your Lordship, this is better copy. Because it's a Xeroxed copy, Your Lordship. So, serial number 5, Your Lordship, shows this petitioner's name. UAN is the Aadhaar name, which was given long back on 13th of November itself, Your Lordship, and the EPS number as well. Your Lordship, the affidavit filed by us on the last occasion that was affirmed on, to which they had to file an exception. March 2025, we had filed an affidavit in which we have given in Annexure A, page 6, the data of by which the workmen had been paid the Provident Fund. The order dated 18th January 2023, passed by this Honorable Court, Honorable Justice Rajabashu Chaudhary, records that we have paid an amount of rupees 2,81,308. Thereafter, Your Lordship, the order dated 19th March 2025 records that he is getting a pension. The learned advocate representing the petitioner submits to have received rupees 86,256 as arrears of Provident Fund pension. It is further submitted that the petitioner has been receiving the pension for each and every month. Now, what is the grievance of the petitioner? The petitioner may say, the PF authority has said, to which I have satisfied your lordship, that pertaining to this petitioner, this is not a PIL wherein he is making submissions regarding other matters. Your lordship is taking up one particular matter, so I can satisfy your lordship on this particular matter. If he is submitting that we've not given any documents, I can file a comprehensive affidavit stating what documents we've submitted. Because the 7A proceedings are going on, where we have given all the audited documents as well. We've submitted all the documents. So it is not that this letter itself shows that his submissions are incorrect. He's not properly instructed. Respectfully, I did not interject when you were making your submissions. I allowed you to make your submissions. I may be a junior, but allow me to make my submissions.
So this issue would not have been, blown out of proportion if you had appeared before this court on the dates when we were supposed to.
I bow down to your lordship. I apologize, your lordship.
You are never to be found.
Your lordship, I apologize on my...
You file an exception to this report stating as to what you have provided
on
them.
the last occasion, 10th of April order, your lordship directed them to file.
They have filed listen to me. They have filed a report stating that you have not assisted them in providing them the details they sought for. Now that you are saying that you have already provided that, you file an exception to this, that you have done it, so that they can proceed with what they are required to do to suffice the requirement of the petitioner.
Your lordship, we do. The learned senior may provide the copy of the
Sir, you give him give her a copy.
But one thing, what the petitioner has stated,
the petitioner is online.
He's not an advocate for the petitioner. He's advocate for the PF.
Because I was answered in this question, my lord. That was
affidavit in the form of the report in the form of an affidavit filed by the learned advocate representing respondent number 1. Employees Provident Fund Organization in compliance with the order dated 29/7/2025 be kept on record. The learned advocate heard the submissions of learned advocate representing respondent number. You are
3.
Respondent number 3, who is to file. Now you get proper copies.
I will. I get a typed copy, your lordship.
My lord, exception to the aforesaid report.
Your lordship, my director is personally present, though there was a order. His appearance.
There was an order online also. He could have been present.
Your lordship, they are not so tech savvy that they could.
So you could have made provision for them to be tech savvy.
Your lordship,
so
his appearance may be
dispensed. His appearance, he is appearing because of you.
Yeah, I apologize.
The personal appearance of the. Who is he? You give me the.
Subroto Nashkar. I'll give it in a slip, your lordship. I'll write it.
He is representing whom? Respondent number
3, Delta Limited. He's the director.
My lord, I am for the petitioner.
The representative of respondent number 3.
He's the director, Subroto Kumar Nashkar, director of.
Representative of respondent number 3 is noted and dispensed with.
Sincerely obliged, your lordship.
So this entire issue wouldn't have prolonged for such a duration.
But my lord,
but for your absence,
I apologize.
In the last hearing, would have taken.
Sir, now you cannot cast the blame on them. Now that they are going to assist you.
My lord, that was on regard to the slips, my lord. The petitioner asked for the slip. That's the reason your lordship has asked me for the slips, my lord. Slips are different.
Sir, once they are there, and if they are not satisfied, let them come up with their dissatisfaction.
Yes, ma'am. All right, ma'am.
Your lordship, accepting to be filed on by Your Lordship.
8th of September.
And matter shall appear on 8th of September.
8th of September.
Sincerely obliged, Your
My lord, 13th August, a separate date has been fixed for this matter.
13th August.
Yes.
Online, this matter was appearing that it is due to appear today, Your Lordship. On 29th of July, this matter was taken up. The
What is the next date? But the order sheet
order is not uploaded, Your Lordship. कहाँ है order डाला?
What about?
Status order जो सब status order.
1st August. It was on
13 August. It is advanced to 1st August.
13th 8th September.
Next.
8th September actually.
Appearing on behalf of Union of India.
এটা কি নেবে নিয়ে যাক আসুক none appear to represent either of the parties. Let the matter be dismissed for
I am
default.
appearing on behalf of Union of India.
None appear to represent the petitioner. The learned advocate representing the respondent Union of India is present.
Mr. Shomo Mojumdar is appearing for the petition, my lord. I am unable to contact the advocate on record, your lordship.
Let the matter be dismissed for default. Next. This is disposed of on probation.
Item number 2.
Allowed.
Grateful, lordship.
আর তো কিছু নেই না 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 assigned matters বা না ও তো এফএমএ হবে এফএমএ ছাড়া অন্য কিছু নেই $235 দেখি রেকর্ডটা Nordesh. Conviction under section
376.
what was the sentence
7 years.
7 years who is there for the state
My lord, in this matter, Ms. Faria Hussain is appearing for the state.
why CBI is there CBI is there
No, my lord, this is a state.
এটা কে ও এ টাইপ করেছে এদিকে আসুন it seems I have heard to certain extent. Have you filed written notes?
No, my lord.
You filed written notes. Ashwin, you first filed written notes. Today there is hardly any time. I'll fix it up on the next date. You file the written notes, then on that day itself, I'll hear you out. The learned advocate representing the appellant is to file the written notes of argument on the next date of hearing. Next date be fixed on 3rd of September.
3rd of September.
September. I ordered to correct করবো CBI কে ঢুকিয়েছে
3rd of September.
Item number 196.
Item number one. For the respondent's matter.
Mapping on behalf of the petitioner, my lord, in the morning, Mr. Hon'BLE ID, senior advocate, had mentioned the matter before your lordship because he is out of station due to some personal difficulty.
My lord, not the direction as was, my lord, given to us, my lord, in respect of filing of the affidavit and stand of the ICC, everything has been disposed of, my lord, disclosed before your lordship by affidavit. So now, my lord, my learned friend is asking time, so my lord, I leave it to your lordship, my lord. This is that matter relates to, my lord, the sexual harassment by a, my lord, a professor in the institute.
August. 11th of August.
As it was it is, my lord.
On the
Item number 197.
My lord, I'm appearing on behalf of the petition 197. It is that matter, your lordship, where the
এটা কোনটা ছিল? 196. আচ্ছা Where is he?
I don't know, your lordship. Day before yesterday, my lord has directed them to clarify that.
Yes.
Lordship, their lordship. Every occasion, your lordship, my lord, have to issue a rule against the MD. Lordship, everything. Every time, your lordship. My lord, the recovery amount is 68,097. With interest, I'm paying.
Where is your
My lord, I don't need to have any exception to that. They have filed their report. I'm not using because I'm covered by the order passed by the Honorable Supreme Court that recovery is impermissible. I'm just placing the judgment of the Honorable Supreme Court 25-1 Supreme today 671 paragraph 12.
but madam, in their absence, how can I dictate?
Lordship, every time, your lordship.
Then I have to issue notice again. Or else you ask him to come. You find him out.
Give a call in the morning that the
Who is he? What is his name?
Shuddhodev Adok.
He represents the
MIC, the mine irrigation. Let respondent number 3, 4, and 5. Lordship, yes, madam. 3 and 4.
Acha.
Division 5 also.
Let him face some consequences at least. I mean, this is not done, madam.
Lordship, I know that, but every time they are doing, I gave him a call in the morning that the matter will be taken
He
up.
has repeatedly not appeared.
Lordship,
It was fixed for orders
Lordship, on
on
several times,
12th
your
of
lordship.
March.
Lordship, since then, your lordship.
Tomorrow you will be there?
Lordship, if my lord directs me,
Yes, please come. Tomorrow I'll get it done.
Lordship, I will come tomorrow.
Yes. But we learned advocate.
Great. I will give him again a call.
You give that judgment that we were referring to.
Rather, it's a paragraph 12. Grateful election.
Item number 200.
Well, I'm for the respondent claimants. Well, I'm leaking.
Dear Malad, you heard the matter and we have filed our written notes of argument. Anyway, Malad, my first point was, Malad, that Malad, the victim was not involved in the accident. That part, Malad, I am just leaving that. Today I am on the quantum issue. Malad, the victim, the claimant claimed in the claim application that the victim used to earn rupees 3,000 per month, and also Malad gave evidence before the tribunal that yes, 3,000 per month. But the learned tribunal assessed 6,000 per month. This one point, Malad, and other part is all right, Malad, and another issue, Malad, 9% interest was granted towards the Malad compensation amount. These two part, Malad.
No, is it an injury case?
No, death.
Then who has given me this judgment with injury case?
Yes, but I have given it only for regarding monthly income. Only monthly income regarding. I'm not saying this anymore, my lord.
Your issue is
Admit.
You said in unknown person.
Unknown person.
Who is unknown?
Deceased.
But my lord,
Deceased is unknown, then who are the claimants?
According to the
in all the records, written complaint lodged, an unknown person met with an accident. In FIR.
So suppose all of us are walking on the street. Something happens. Everybody knows everybody.
Charge sheet also says unknown person. In any before
And then how come the claimants come into the picture?
That is the question.
That is the question.
Anyway, Malad, I'm leaving that issue, Malad. Today,
That
Malad, that issue, I'm leaving that issue. Today we are Malad.
You have to take an issue. You have taken an issue.
Taken.
And what?
Regarding Malad income and
income, what?
3,000 per month. Because Malad in the claim application, you also kindly.
So 3,000 was excessive.
Yes, 6,000 Malad granted.
3,000 or 6,000?
6,000 granted. 3,000 in the claim application claimed. This is used to undo 3,000 per month. Claimant adduced evidence. Yes, my husband was used to undo 3,000 per month. But in the judgment, learned tribunal granted 6,000 per month.
Where is the judgment?
My lord.
Page number 39.
Page 44, last paragraph. With regard to page 44.
With regard to income of the disease.
Yes, income tax. From last paragraph, next page also. Considering the decision of Apex Court, without ignoring the.
When did the accident take place?
In the year
2008.
2008. Now, whatever it is.
On the basis of 3,000, we are giving calculation. But the other portion, other portion, all right. Regarding multiplier future prospect, that is all right.
What he used to do?
Labor.
He was a labor.
Labor.
Regarding income, there is no evidence. That future prospect also granted, my lord. General damage is also granted. That part we are not on that.
14?
No, was it under 163A?
No, my lord.
166.
Huh?
166, my lord.
166.
Then affidavit in chief of PW1 in page number 6, it states that I have filed the case, filed the above case under section 163A of MV Act.
No, this is a mistake, my lord. This is a mistake, my lord.
I think, my lord, thereafter it was amended because, my lord, amended claim application is being annexed here, my lord. In the judgment portion, first page, I find, my lord, the application under section 163.
When was the complaint filed?
Right on.
Where is the complaint?
Regent Park PSA 15/1/2008.
15/1/2008. When was the accident?
15/1/2008 at about 10 hours, 23.10 hours.
When did the accident occur?
Well, 15th January 2008.
So the
Page 18, your lordship. Fine.
no, page 13 is what? The complaint.
Page 13.
Page 1.
Is also a complaint.
Page 13 is the complaint. It was marked as exhibit.
Yes, ma'am. 15/1/2008. 11:20 minutes.
You are sitting here from the morning itself. You will not go through the records. Nothing at all. When you will be asked, you go on.
Kindly, better, my lord, kindly come to page 18.
Written complaint is marked exhibit 2.
Yes, page 18, my lord.
আচ্ছা কেউ আছে এখানে? কে নেবে?
But on the basis of 3,000, we are giving calculation.
No.
Well, kindly come to
No,
page
that
1.
now see there is a reason.
Well, kindly come to page
No,
1.
now
my lord.
the tribunal has applied the ratio and
No, my lord,
mentioned
yes, my lord,
everything.
Then, my lord, kindly pleadings and evidence, my lord, kindly come to page 1, my lord.
ISS, no.
Well, kindly come to page 1, my lord. Page 1.
That I have seen.
Yes, my lord, page thereafter, my lord, page, my lord,
12.
The page 6.
দেখি এখান থেকে
15/1/2008.
ইনকামের জায়গায় চলে গেছে ইনকামে
3,000 per month. Yes.
3,000. Page also gave evidence that 3,000 per month. The pleadings evidence says, my lord, 3,000 per month. But, I'm paying only for that, my lord.
আচ্ছা, I'll keep it aside. Let the regular ones come. I'll dictate. By that time, let me hear out the other one. What to do? Yes. 201.
You know, the 201 is my appeal.
Tomorrow, none of you are coming. What? You, in any occasion, you hardly appear. Mr. Bhomik, he's shrugging his shoulders.
Lord, I've been threatened, Lord. That's what I say, Lord. I won't take the names.
Who has
I won't take
threatened
the names, Lord. But then just to not to, Lord, say yes.
today's leftover matters
Lordship.
will be disposed of tomorrow. So whosoever, because then only I have seen the list and everything. If we finish it off, then Monday onwards, we'll be back to our regular list of matters under
Sure.
for orders. These are all your accumulation through 3:30. You come early in the morning, first half, then go and take rest. And if you don't appear tomorrow, no adjournments. Hence onwards. Let us finish it off.
But yes, I agree. I agree.
Applicable only for orders.
Yes, only for orders. So you don't have a matter
Doesn't
for
have-
orders.
No, look at the smile in his face. These are the people, my lord, who are the real culprits. No, the smile of your face, you know.
Now, as much as we can do today,
Lordship. Lordship.
then we'll exceed 3:30 then.
Yes, that will be
That will be done?
Yes.
Okay. So then don't look at your back
no,
after 3:30. So today we'll finish off with the list.
Lordship, my lord, 201, Mr. Ashik Mondal is there. He had a medical emergency. He came to the court, then he left, my lord. So,
You are appearing for whom?
No, my lord, item number 80. In the morning, I have mentioned the matter. There is a contempt matter before court number 37. Your lordship was pleased to dismiss the matter. I am appearing on behalf of the private respondent. My affidavit is here, my lord. I will file my affidavit. 80.
Sir, you could have at least sent your junior.
But today, my difficulty is my junior has broken his leg.
Oof.
You will not.
So you'll have only one junior.
Yes.
But I find many people are
They are
accompanying you.
Yes, they are solicitors people. They are the junior advocates of solicitor. They are briefed me. That's why your lordship has.
The record is not there, I believe. Ache. না ওরা 3টে বাজতে যায় to represent the petitioner, the learned advocate. You are representing whom?
All right, affidavit, respondent number 426, 8 to 11, and 13. All are
Representing the respondent number
426, 8 to 11, and 13.
426, 8 to 11, and 13 has filed the affidavit in opposition. Let the same be kept on record. Let the matter be adjourned for the day. Yes. Yes, Mr. Singh. Who is your other side?
Lord, as I said, my lord, 201.
Tomorrow he'll be there?
My lord, 201, 200, your lordship will only make it, my lord, not today. Lord.
Yes. Sure. Ashun. The learned
Lord, I'm for that. My lord, this was the matter my lord was hearing yesterday. The two grounds, my lord, what I had taken before your lordship.
You had to place one judgment, though I have seen that also.
Lordship, I'm grateful.
Yesterday, I'd seen it.
I'm extremely grateful to your lordship. My lord, then my lord must have, my lord, taken
But
note
there
of
is a
the
distinction, sir.
lordship. Yes.
There is a distinction in the sense that
Mohammed, beta, no.
no, we have to go.
But your lordship will only have a look at this chart, my lord.
Sir, I have seen. I'm not on that.
Kindly, my lord, I understand. I understand.
What I mean to say is that
Yes, to
the
Joshua.
sudden appearance of the cow in front of the
Lordship.
so there.
So, my lord, sudden stoppage of the motorbike in front of me, that also, my lord, gives me that, my lord, kindly give me that indulgence as well. My lord, this is in reference to the judgment what I had given, my lord. Just
I had gone through that judgment yesterday evening.
lordship.
So that's why I'm telling.
Lordship.
That's why I'm saying
My
that
lord.
there is a distinction between the judgment. I'm not on the intent.
Lordship.
Right? I am on the issue of the circumstances.
My lord.
Right? Here what happens, all of a sudden this entry of the cow is there,
My lord. Yes.
which disgruntled you to a considerable extent.
I'm sorry.
But here again, can you attribute that solely? So you have said 50%.
But if not 50, 40 minutes, my lord has to decide that not in my lord, the inquisitorial jurisdiction, your lordship will decide that. But I say, my lord, if for his sudden stoppage, he is not responsible, then but how can I be made responsible for that? Because Supreme Court.
There's a point. It should not be entirely.
Because, my lord, Supreme Court here in, my lord, in this case, has made the car in front, my lord, 50% responsible. After going through the tribunal's finding, after
Yes,
going,
the car suddenly
stopped.
And here he was compelled to stop.
My lord, the physical act of a stoppage is there. My lord, Supreme Court has said since the genesis.
There is a difference in terms of the facts and circumstances.
Sir, why shall I be made responsible for his facts and circumstances, for his ill luck?
So you are in any case being made responsible for the ill luck sustained by all and sundry, sir.
My lord, to certain percentage.
For all and sundry.
My lord, if
a victim of an accident, be that resulting in the death
Lordship,
or
I am
sustaining injury are through an ill luck.
But my lord, when my lord 166 proceeding, my lord, the negligence is to be looked into. My lord, it is a must. My lord, Supreme Court, my lord, I have just given them, my lord, the gist. My lord, the Supreme Court is very clear, since the genesis of the accident was the sudden braking of car. Where the whole thing started, it was sudden braking of the car. That is why the car has to make.
What did I tell you, sir? That I had gone through
I'm
it.
grateful to madam. I will not add anything further to this.
I have, at the very inception, told you that yes, you have a point, but there is a distinction with regard to the facts and circumstances. There, in the case before the Supreme Court, the sudden application of the brake was not due to any other, by the virtue of any other ancillary incident. But here there is. So maybe, yes, as you are saying, that why the entire liability should be cast on you. So that
your lordship will kindly grant
has to be reduced. It cannot be absolutely 50%.
My lord, may I just, my lord, kindly, not misunderstand me. My lord, I'll just walk the other way around. My lord, there are innumerable Supreme Court judgments, my lord, wherein a truck is parked on the side of the road without tail lights being on. I drive my vehicle and I hit the truck. Truck is stationary. I am driving. My lord, the truck has been made solely responsible that why were you standing there? Even if you were stationary, since your tail light was not on, therefore, entire responsibility is yours. Trucks. A stationary truck, my lord, is being made responsible for 100%, my lord, negligence. In this case, a moving vehicle suddenly stopped in the middle of the road, and my lord, still, my lord, then your lordship will kindly understand from that analogy, my lord. This is the other way around. A stationary truck, 100% responsible, that why were you standing there? And here a moving car stops.
I
A
mean,
moving vehicle
truck
stops.
stands at its own volition.
Yes, my lord, maybe the tire puncture, maybe for other reason, maybe the khalasi was eating food, the driver was eating food.
If the truck itself does that,
My lord, truck was all,
immovable property.
my lord, truck was already standing there.
Hmm.
By the side, I'm not even on the middle of the road, my lord. By the side of the road, at night, the tail lights were not on. There are a number of judgments, my lord. I drive my car and I hit the truck. Supreme Court says that why your tail light was not on, you were stationary, you were not moving, truck. But still, the truck is 100% responsible. I have got no responsibility. I went and I hit. In this case, the vehicle which was moving stopped suddenly. Then, my lord, at least in that case, my lord, that when the stationary truck is 100% responsible, then how come a moving vehicle which stops in the middle of the road cannot be made
You
responsible?
don't try to convince me, Mr. Singh, in that way, because I'm already convinced.
My lord, I will not add anything further. I'm grateful to your lordship. I will not
What
add
I'm
anything
trying to tell you is there is a difference in circumstances. Here, the person had himself applied sudden brakes. And in your case, in this particular matter which we are dealing with, it was the abrupt appearance of the cow. What is on evidence? Neither you went to see whether the cow had been there, neither he went and saw, neither the court. Right? Whatever it is appearing from the record. So when all of a sudden there was the appearance of the cow in front of the vehicle, it was forced, it was compelled to
My lord, in this
stop.
case,
In
the wife, my lord, was sitting in the car. She felt, my lord, absolute unwell. She felt like vomiting. The person who was driving said, okay, it's a sudden urge, my lord, so he stopped it. So, my lord,
that is a different issue. That could have been, sidelined, that could have been taken to a particular side. Let's not go into those nitty-gritties. But
my lord, I'm only on the point, my lord, this fault cannot be entirely of mine. He was moving, I was moving behind him.
you are only interested with the money. So
I am only interested in the lordship judgment. Because of lordship, the submission at advance by Mr. Singh.
How will you get the money without the judgment?
Kindly allow me for 5 minutes. Lordship. I know my everything is bad. Lordship,
What is
under
bad?
Pressure, everything is bad.
Everything is bad. Means what?
Kindly see the judgment as referred by Mr. Singh under the impression that both the vehicle under the national highway. Under that impression, the internationally the high speed gadi running was someone stopped, someone hit. But lordship, kindly see that judgment is referred. Kindly see the judgment, paragraph 6. There's the highway, and lordship, kindly see what is my case. The Asansol Dumani road. But I have searched what is the status of the road. The status of the road is there, very narrow, congested, and the crossing road, and the maximum people and the bazaar, everything is there. This is not national highway. So the conception is placing before your lordship under the impression if the national highway it's happened.
Let me cite you an instance which happened today in the morning out of court. Okay.
And lordship, kindly
We
see.
were passing. We crossed Baliganj Fari, right? And when we were coming towards Birla Mandir, prior to that, all of a sudden, a scooter with two persons, one was driving and the pillion rider, it just came in front of us. From nowhere, from the opposite side. In front of that Sunny Towers.
Yes.
In front of Sunny Towers, or prior to that, or
maybe in front of Birla Mandir, it's Sunny Tower or Modern High.
No, we had crossed Modern High. And then the person who was driving the car, he somehow could, turn to the left. And then these people went away. And I just exclaimed. And then instantly this matter struck me.
My lord, in this case, who would be responsible? If the sudden and abrupt break.
Now, if somebody was there
behind
and he had applied the brake,
lordship, then they would
he
have
somehow could.
It was managed to be saved. My lord, it was managed. It was managed to save the car. But my lord,
But then as he said, it's a congested road. Then he pointed out to your national highway issue, and on the very road that we were plying on was neither a, I mean, it's neither a national highway nor it's a congested. But okay, during office hours, you hardly find space because there's a continuous flow of vehicles. So then if he had stopped and somebody from behind would have hit, so it would not have been 100% the fault of the person who is from behind.
or even if for that matter, if my lord's car had hit that scooter, but it wouldn't have been my lord's car's entire fault.
No.
It would not have been my lord's car's
No,
entire fault.
No.
If my lord's car had hit that scooter, had my lord's
car
car been, had my lord's car been 100% responsible.
What logic? Yes, let us listen to his logic.
So also kindly see the case.
No, you come to this logic.
Logic is this. Lordship, I am placing a Supreme Court judgment where Lordship found the.
No, please, not to my case.
Given by the Supreme Court, Lordship. I am who I am to give the logic. Here says the unexpected development was for the driver to have explained how this happened. So Lordship might.
Which driver?
Any of the driver. So here one of the driver is present, and suppose that offending vehicle driver is absent. In absence of his explanation, the doctrine res ipsa loquitur will apply. Therefore, let's kindly see the petitioner, he could have proved the actual cause of accident. But here, the driver evidence is absence. Let's kindly see that the offending vehicle driver did not produce before the court of law. There is evidence is not there. If their evidence will come, then assessment can be made on that score the degree of contribution to the accident. I have the claimant, one of the claimants also riding the scooter. He said the offending vehicle is absolutely so liable for that. But in absence of contra evidence, in absence of rebuttal evidence, then how the court will assess this submission is absolutely wrong. In absence of rebuttal,
he is on the point of apportionment.
Apportion, yes, they are saying so.
If
20%, 30%,
who will assess the extent of liability?
Yes.
So since the driver of the
this Maruti Karina case
was not there, how to
entire liability of the person who is confessing that he stopped in the middle of the road.
Kindly see the one person traveling in the bus fail or whatever, but after that Supreme Court come to a conclusion. Lordship, kindly see the paragraph 8. I will not give more trouble to your Lordship, just see. It is not that required to be discussed, but Lordship, kindly.
Which page?
Yes, that page I have opened. This is the paragraph 8. Paragraph 8, Lordship, kindly see. The unexpected development. The sideline is there. Paragraph 8.
No, it says the evidence in the case indicates there was no traffic on the road at the time of the accident. No untoward incident took place like sudden failure of the brakes or an unexpected stray cattle coming in front of the bus, and still the vehicle got into trouble. In absence of any unexpected development, it was for the driver to have explained how this happened, and there is no such explanation forthcoming. So it says, in absence of any unexpected development. So here there has been a development.
No.
The cow had come.
Cow had come in front of my vehicle, the victim vehicle. Cow has come in front, suddenly cow has come in front of my vehicle. I press my brake and the offending vehicle hit from behind and the pillion knight got fell down and got injury, ultimately succumbed. That is my case. So the hit by whom? The offending vehicle. The driver has to explain. Is what is his contribution? Is 100% contribution or something contribution? Unless and until that
You give me the reference, a copy of this.
Yes, Lordship, there is the yes that I
Yes.
Lordship, kindly see the Bosti Kashem Sahib versus Mysore State Transport Corporation.
In such a situation, the principle of res loquitur applies.
I am inviting that doctrine. Lordship, kindly invite, gradually apply that doctrine. Then entire problem will be solved.
Yes, you have solved my problem. Thank you. Thank you so much.
My Lord, Lordship is telling with the story with Mr. Singh.
I am not telling a story. I just said
No,
that
fact,
this,
fact.
I have
I'm sorry,
faced this.
Sorry, Lordship, sorry, fact. But with whom? Mr. Singh. And now see the Mr. Singh.
What? I did not share with Mr. Singh. Who is Mr. Singh? I was just relating to all of you.
But Lordship,
You check your...
no, Lordship, kindly, it's a different issue. But Lordship, kindly see here, the case is something else. The judgment as referred by Mr. Singh is not at all applicable in this case. This is a highway case, national highway. Kindly see paragraph 8 of this judgment as referred by Mr. Singh. Paragraph 6. Middle of the highway is not reasonable explanation.
মানে এদের সাথে কোনো কথা বলাও সমস্যা। You should only be scolded. That is the best part.
I'm just here. That is the last line.
Okay, I have seen.
But defense failed to produce any evidence to support their such possibilities. I'm with the Xerox photocopy.
No, I'll find it out. I have taken the citation.
And Lordship, one thing is that, Lordship, here, Lordship, kindly on the question of quantum that I have filed on cross objection, Lordship, kindly see that the learned tribunal considered the net income of the deceased. The subject is just very short submission I have. Lordship, just with the help of Mr. Singh,
Cross objection এর copy আছে?
Yes, that is in the list. Lordship, kindly see the judgment what the learned tribunal considered. Lordship, kindly come to page 72 of the judgment. First, we will find the figure near the member. Is 60 the member? একটুখানি দেখে নাও gross income and Lordship, got it, page 60.
72 you said?
72. Then kindly 72. Well, Lordship found the 5,13,600. The last paragraph, second line, left hand corner.
Yes.
Then Lordship, kindly come to page 60.
60.
60. The folded page.
Yes.
Lordship, kindly come to the right hand side, fourth column. Lordship, kindly to the net pay. NET PA white and nature. Net pay. Lordship, kindly found the net pay. Found Lordship that column, net pay from right hand side, fourth column.
Yes.
Then after Lordship, the adding those 12 years salary, then average will come 5,13,660. 5,13,600. The learned will consider that aspect. দেখো এটা আবার
এটা তো ট্রিবিউনাল ধরেছে।
So you mean to say it will be the gross pay?
It will be the gross pay minus tax component. Then Lordship, kindly come to the left hand side fourth column.
Gross pay minus tax.
component. Then lordship kindly come
Tax
to,
is in which column?
I'm showing lordship that the fourth column lordship will pay gross, total gross. Fourth column.
That I have seen.
Yes. Then lordship kindly the next lordship kindly come to the column number 9. Professional tax 200, 200, 200, 200 means 2,400. And lordship kindly see the gross income. Income tax. There is a column number 13. Income tax. Lordship kindly see the
5,200, 3,000.
Yes. Then lordship it will come 56,724. So 56,724 plus 2,400, it means 59,124. That has to be deducted from that is the tax component deducted from the gross salary. The other part is entitled.
Okay.
So if lordship consider the other part, then lordship gross income 7,32,349 minus 59,124, then amount will come 6,73,225. So that will be the
that we have to calculate and then.
Again the same difficulty. Then why not the tax? This income tax return.
That is income tax return. That is there.
Which exhibit?
Exhibit lordship 13.
Which
18,
page?
18, page 60. It's income.
Page?
It's income tax. Page 60. Income
Page
tax.
না এটা তো স্যালারি স্লিপ দিয়েছে এটা তো কে ইস্যু করেছে এটা ইনকাম ট্যাক্স ডিপার্টমেন্ট ইস্যু থোড়ি করেছে
After deduction of income tax, the employer has come and say the salary sheet is exhibited from the side of the employer that income tax has been deducted in such way.
No, this was the issue, I think, in that Mr.
In the other Mr.
Mondel's
Mondel's matter, it was remanded work for 1 day. You file your income tax return, whatever you use 6 lakh, 7 lakh, 70 lakh, whatever that is, you take it.
There you are saying on other things. Lordship, here the income tax issue is there. Income tax already been deducted by the employer. That salary statement is there. Why you will go beyond before the?
Not in addition to that, what tax he has paid, I am not aware. I do not know
after that,
what he was entitled to, what he was liable to.
That is already deducted.
Then why was it not shown? Then it should have been shown.
And
hearing
lordship,
concluded, CV.
Lordship, one thing is that the learned tribunal deducted 1/3. That should be 1/4 because of 4 claimants are there. And lordship, the 15% future pursuit that learned tribunal declined to pass any future.
আচ্ছা ওই যেটা বাকি আছে আগে ওটা ডিকটেশনটা দিন তারপর আমরা বলবো
Lordship, kindly see that the future pursuit declined here.
দিচ্ছি
এটা
But if I take, my lord, your lordship, my lord, to the memorandum, my lord, page 47, paper book is there. My lord, involvement is, my lord, doubted. 7 days after the accident, my lord, the first information report has been lodged before your lord.
After how many years?
7 days, my lord, and the involved 7 days after the accident, my lord. The
7 days.
7 days, my lord, and my lord, this in this offending Tata Sumo.
There's any cross objection? No.
Yes.
Hmm?
Yes. Cross objection.
2015, there's no cross objection.
Cross objection is not in the list.
Not in the list.
No.
Did he file any cross objection?
Yes, he has. He has filed a cross objection.
The letter to list in it.
No, it is not in the list.
What is the number? Chanchal.
My lord, I cannot attend before honorable court today due to my heart trouble.
Why are you reading it out, Mr.
But I'm
Singh? It's
sorry,
not
Lord.
required.
But I'm sorry, my lord. Court will be listed. FMA case, my lord, court number is not provided. My lord, Lordship, kindly grant me 1 second, my lord. Tumpa Bowri, court 83 of 25.
80?
83, 83, my lord.
Of 20?
25.
Issue. Of October.
28th October.
If at all, it seems that now we'll go back to years prior to 23 and 22. It's better that at least people are coming.
Yes.
24, 25, people are not interested. They want to drag it on.
My lord, next matter, this item 216, my lord, is also the court is there.
The same person.
Same person, my lord, Mr. Ali Imam.
Hello, same order.
89. Court is 89 of 25 in item 216, my lord. 28th of October.
They are not practicing here.
My lord, he comes from Bardhaman Court. He is a practitioner of Bardhaman Court, but my lord, lately he has started coming to High Court, my lord, for the last few years.
He can as well appear online. Where is the harm?
Online, my lord, he is not that comfortable. That's what it.
Sir, they continuously go on fidgeting with their mobile and everything that they will do. They won't appear online.
My lord, 220, Bandana Mondal Tata. Lord, Ashik Mondal, my lord, is there. I am for the appellant.
All these matters will be tomorrow. If tomorrow nobody comes, I'll dispose.
Lord, will.
Please, you people can see. From 37 yesterday, I got it to 15. So I thought by today and tomorrow, if those 15 gets disposed of, then Monday onwards, we'll be on the regular track. Who is this Shamim Ahmed?
Milord, I have got the brief, Milord, for Mr. Ahmed. This Conway Patra. This is the appeal of insurance company. Milord, I'm appealing.
Objection.
Cross objection.
He again doesn't appear. 2025.
225, Milord, is Madhavi Shardar. I am for the appellant, Milord. And Mr. Sirajul Islam, Milord. Paper book was supposed to be filed by my learned friend, Milord, to appear as for orders. He is not here today. This appeal, Milord, was solely on the ground of quantum, Milord. Consortium was granted in excess. So your lordship was, my lord, 1,76,000 was access granted in consortium. Lordship, my lord, for 4 different persons, my lord. Your lordship wanted to dispose it off without paperwork. Is not here today.
But you have to get the other side
But,
with
my lord,
you.
that's what I say, my lord. Mr. Sirajul Islam is there for the other side.
Then I'll issue notice. I'm giving you people a lot of chances and leniency, I must say.
Sirajul Islam আছে তোমার 207
Mr. Mondal and Mr. Pal, you have a matter?
Sirajul Islam 225 Madhavi Sir.
233, 234.
33 and 33.
And who is this Anjan Chakraborty? You are there. Who is your other side? Where is he? So first of all, let's do this. 233 and 234. Come.
Paper উঠতে দাও।
Mr. Singh, on the next date, you ask these people to be online if they don't come.
Lordship. Lord, Monday, I'll see to it that they all are physically present.
Monday, again, this numbers will increase. Then again, Monday, there will be a 3:30. But if it at all there is a 3:30, I will not. I will continue. Can you ask all these people to appear online if they are not present in court?
Yes, Asha.
Yes, sir.
But, although I have taken income ground.
Or else I'll record their absence for so many days and then I'll pass the order.
My lord. But I'll sit with Monday, they all are.
Yes.
But, although I have taken the ground of income, but subsequently I find that there is a sufficient materials on record that the London Tribunal assessed income rupees 8,800 per month on the basis of pay slips and income certificate issued by the employer. That is not sufficient, but anyway, I'm leaving this point. My first sole point, main point is disability certificate. Disability certificate issued by the medical board, page 47. Is that page 47?
Page 47.
Page 47. Kindly consider the date of accident is 21st September 2010. Can you just note? Page disability certificate issued by the medical board on 1st University at the top, dated 17/10/2012. 17th October 2012.
Yes.
But it's 17/10/2012. The date of issuance of disability certificate. Date of accident is 21st September 2010. Now, kindly come to the evidence of the victim. It's an injury case.
80%. What has happened?
80%. 80%. Post. There is no amputation, but orthopedically.
Now, what do you want? What is the problem with your disability?
Kindly come to the page 7. Page 7. That is the evidence of the victim. Page 7, paragraph 5. That the doctor of Vision Hospital as well as ESI Hospital Shelter several times operated by me injured leg. Well, only this document regarding the disability certificate or regarding the injury of victim, only this document, nothing. A scrap of paper has been exhibited before the tribunal. discharge certificate, to case history, nothing. Only this disability certificate regarding the injury. No other document.
And so why didn't you raise this issue?
Yes,
You have raised?
Yes.
What else?
Yes, my lord, page 16.
Page?
16. 16. Third paragraph.
Yes.
The insurance company also contended that the disability certificate was procured after a long gap from the time of the accident. From the said certificate, it cannot be understood that the disability had any connection with the alleged accident. This I have raised. A scrap of single scrap of after accident. And the issuance of disability certificate. These 2 years.
From the said certificate, it cannot be, this is the submission.
Yes.
Cannot be understood that disability had any connection with the alleged accident. In this regard, I am to bank upon the charge sheet filed in the criminal case lodged against the driver of the offending vehicle in relation to the alleged accident. The charge sheet is the net result of investigation which was filed under section 279 as well as section 338 of IPC. Section 338 of IPC speaks of sustaining grievous hurt. In the instant case, the petitioner suffered grievous hurt due to his accident such and such. It cannot be presumed that a hurt which is grievous in nature will be mitigated in short period of time, leaving no trace of it on the body of the victim. Therefore, I find it preposterous to accept the logic tried to be propounded by the learned counsel for the insurance company.
The basis of grievous hurt, as made in the charge sheet, tribunal discarded my submission.
Yes.
A single scrap of paper, only. He stated.
Now, did you who had appeared for the to get this document exhibited?
My lord, the medical board, my lord, here.
Which page?
My lord, page PW2, page 10.
I'm posted as accountant, such and such. I'm also the superintendent of SD hospital, has received summons and authorized me. This is the where is the disablement certificate?
My lord, page 47.
47.
For page 47.
Nowhere mentioned that this disability or this injury is out of that accident.
Accident has been happened.
Show me the complaint.
Complaint, yes. Page 31, my lord.
Page 31.
Page 31.
This first he was removed to ASI hospital.
Yes, sir. Thereafter, my lord,
to Mission Hospital.
Yes.
You did not get anybody from the Mission Hospital?
Three persons have been adduced evidence, my lord. One PW1 is the himself, and PW2 from the disability certificate due to another is my lord PW3, my lord employer. And my lord, in the certificate, my lord, in the certificate, kindly see he has been removed from service. My lord, kindly see in the page 62.
That was issued after accident.
Yes, my lord. After accident, he has been removed from his job.
My issue is, my lord, whether this disability is
Hmm.
arose out of that accident or not, there is no proof.
My lord, here up
There is
to
no documentary proof.
my lord, according to there is no contrary evidence, and according to my lord, the deposition, he was admitted twice.
Yes.
Yeah, he was admitted twice.
That is
And 31st May, up to 31st May 2011, he was in the hospital.
Which hospital?
PSI and
PSI.
Mission Hospital as per their oral statement. Now the question is, where is those documents?
Accident has been happened.
Where is those?
Grievous act has been happened, my lord. In the charge sheet, I think all document was placed. My lord, in the certificate issued by the employer also stated motor vehicle accident is there.
Was not the eyewitness.
Before my lord termination, absolutely there is, my lord, some investigation by them. And he himself appeared before.
When did the accident take place? 2010.
2010. Up to 2015, my lord, he was in the hospital. Thereafter, my lord.
Which he was hospitalized for 5 years.
No. 2000, my lord, 31st May 2011. Up to 2011, May 2011.
So where is the document? Hmm?
And he himself appeared before the, my lord, tribunal.
No, where is your cross as far as the disability certificate is concerned?
This is not regarding disability, my lord.
Is brought for renewal. Today I have not brought.
Page 10.
Did you argue, or you have argued that point? Hmm?
And
So he was
company
not
also.
admitted at ESI.
Yes.
He was not admitted at ESI hospital, but he was admitted in Mission Hospital.
At first, he has taken to ESI hospital. Thereafter to Mission Hospital. Again, my lord, ESI hospital, Sialda. And my lord, the victim himself appeared before the tribunal below. My lord, tribunal taken care of, my lord. For that reason, my lord, kindly see the observation of the tribunal below. That has been taken care of. Yes.
I'm not questioning about. I'm not questioning about the disability certificate. I'm gonna.
But disability, it is.
Whether this disability arising out of the said accident or not, that
But accident has been happened, my lord. Up to
that is
2000
why.
That has been.
That period, where is those document?
medical expenses, 1 lakh. There's no evidence, my lord.
My lord,
Other part, loss of expectation, loss of amenities, and various trouble. I'm not on that. These two heads really troubles me.
my lord, yes, yes.
Yes, traveling, expenses traveling. There no evidence. In fact, they have not
My
paid
lord,
for
it
it.
is
in
not
fact.
possible here
They have
and
not
there.
paid for.
He was
Even I take it for granted this very well. 80% disabled person, 50,000 for traveling expenses. But these two heads that pay that attendance charges and future medical expenses, this one there is no evidence. Kindly consider this as.
My lord, kindly
That
see
part,
the
my
object.
lord, I am not
Page 18, my lord,
traveling
before
before
that.
lordship, my lord.
Yes. Yeah. My lord.
But this point was taken before the tribunal.
No,
This
actually evidence has-
disability portion, this point was
My lord,
taken.
tribunal man seen. My
Tribunal
lord,
only
tribunal
considered the
seen.
charge sheet, give us
My lord,
heard. That is
18,
why.
page 18, your losses will find.
My lord,
2010.
2010.
10. My lord, the fitter, he was fitter, my lord. He was fitter.
MSCC, 8 of 2017. But original number is 231 or 2011. This is the computer's number,
Yes, yes.
2017. But tomorrow I am not coming because I don't have any matter.
Today we have
for orders matter.
Huh? Today we have done, my lord. I have only one matter.
Yes, I have finished my for orders matter.
You have finished.
Yes.
Last. This is the last matter.
Tomorrow, who are having their matters?
Mr. Singh.
Mr. Singh.
Mr. Singh and Mr. Mondal. Mr. Ashik Mondal.
Acha. 229. Both of you are there.
My lord, item 21 and 22, my lord.
Let me finish this off. Yes, sir.
Yes, that is my opinion only. And
মানে মেরে ধরে মামলা করা মানে চেপে চুপে বেঁধে এনে টাইপস থ্রেট করে কি না করে লোকে না জানলেই ভাববে যে কি
এরকম কেস করাচ্ছে।
জোর জবরদস্তি করে yes
yes, Lordship, this is my appeal, and this with regard to inordinate delay of lodging FIR of 48 days as far as the accident is concerned. The accident occurred on 11/9/2013 and the FIR was lodged on 29/10/2013. That is my case. And there is an aspect of like possible
only 48 days delay. What
yes,
else?
and the charge sheet was filed after a lapse of 94 days. That is also there. There is a possible aspect of collusion of the police with the claimant, maybe. That is the reason why you have filed
So
this.
you want that to be highlighted.
That is there.
Where is the complaint?
Page 50 on, my lord.
Huh?
Page 50 on.
Page?
50 on. 5 on.
5 on, yes.
Everything will be clear from that. Accident took place on 11th of September. Then he was shifted from many hospitals. Ultimately died on 29th of October. And on that day, my lord,
Accident was on 11th of September. And 29th of
October, he died.
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 And 29th of October, this.
FIR lost.
Acha. And what medical documents and all hospital?
Medical documents are many.
Treatment and all are there?
Yes, ma'am, they are there. I'm not.
Yes, all are there. Yes, sir.
I'm not in claim petition page.
No, there is no explanation given even into the claim petition also regarding the
claim petition
delay in filing.
Paragraph 13.
Delay of
paragraph 13. Okay, ma'am. Liberty to withdraw the my matter completed. My matter ended. I have no matter tomorrow.
You have no matter to work. I mean, it's
What's the blast to
like I'm done with my work.
Yes,
Please,
ma'am.
please, free period.
Giving an application to leave.
Yes, send me.
21, my lord. এসেছে?
Twenty-one and 22 আমি ইয়েটা দিয়ে দিয়েছি চালান দেখুন চালান Twenty-two also the same. 22 দেখি I do not have any for orders.
Lordship will take up applications. Claim case.
Will appear online then.
My lord, may I have your your lordship, kind leave regarding to mention the matter in item 90. Ma'am, my lord.